What is the exempted from the other from the 2018 matter, Mr. Counselor, but they have filed the requisition on in that month May. May, yes. Last month is pending. So, Mr. Equally, is Kalita for the petitioner is granted. And then this time to file affidavit in reply to the affidavit filed by the victim. Is the matter of the it is in order to contribute to. Hello. Item number two. I have not read that. Item number two. Respondent is like I'm looking for now 406. Item two. What is the instruction? What is the instruction? That's all is there. This scheme was sponsored for government of India. But they have sold the scheme. So they are not giving us the money. Then what instruction will Mr. King over take? You call it, will take it up. I'm for 456. Who is 456? Who are they? Government of USA or what? Deputy Secretary, Government of Assam, Skill Development is 4 months, and Director of Employment Craftsmanship is 5, and the Joint Director Craftsmanship is 6 months. Earlier, then real for the order. Mr. Item 2, you right. Just give me your paragraph. Is the central government a party here? Yes, one Union of India represented to the Ministry of General. Who is the appearing for us? Who's the CDC? Huh? No, we do not know for who he said for all the response. You call Mr. King over, we see. Item 2, don't pass any order. I think no, madam, this is what is it? We have also what is the development? This is the 2019 matter. What is the? No, Mr. Counselor, there is one thing. This is a stone crusher unit, correct? Now the mining has not been allowed anymore by the Supreme Court. Mining is not allowed. So where's the question of allowing you to run the stone crusher? That is not your prayer in the writ petition. In your writ petition, you have not asked for that prayer. Huh? We have not made any prayer. The additional affidavit praying for what? Give me item 86. I don't think anything survives. No, this doesn't survive. You see a prayer. So, subsequently doesn't matter. You file a subsequent petition. Maybe, maybe, maybe. Who has allowed you? Yeah. No, no, I got it. I'm taking it up. I'll take it up. We'll take it up. We take it up. We'll see. You pass you give your mention slip. You cannot do just like that. Application for non-compliance of the order dated 14 to 2025. Okay, right. Heard, Mr. R. Islam. R. Islam, another copy for the petitioner who submits that the respondent was to verify and pay the vehicle hire charges in terms of the order dated 14 to 25 passed in WPC 508324. Issue notice returnable in 4 weeks. Steps within 3 days. This is the matter of the court. Yes, the instructions are there. Now you are appearing for whom? Earlier you said for all. Now you're saying for every commission. We have taken all on behalf of all the first day. Now you'll have to be, you have to clarify. You're appearing for whom? When officers you have taken notice on behalf of F1 number 226 person. He is appearing, Mr. SP Gupta is appearing for respondent number 4, 5, and 6. Right. Right, Mr. And Ramesh Chaudhary, man, counsel for the petition, who submits that the bills of the petitioner number 1 academy for imparting vocational training courses amounting to rupees 29,43,930, not having been paid by the respondent, he filed, no, the petitioner's file, WPC 5611/2020. Quite order dated 2/9/21, passed in WPC 5611/2020. This court had directed the, the the director, employment and craftsman training, Reha PB 42, make a verification and pay to the petitioner. They are entitled to. The same not being done, the petitioner has approached this court again by way of the present petition. Mr. S.P. Gupta, S.P. That, Senate thousand for the respondents number 4 and 6, 4, 5, and 6 has submitted letter dated 1/6/25 issued by the director, employment and craftsman training, SI, which is to the effect that the scheme was a centrally sponsored scheme and funds were allotted by the government of India. However, By email dated 9/6/2015, it had been mentioned that the Skill Development Initiative, bracket SDI, right, was scheme had been closed. The letter also states that the government of India has not shown any willingness to grant any amount due to the scheme being closed. Need to notice returnable in 4 weeks. Letter, I think. No first. Need to notice returnable in 4 weeks. Mr. K. Who accepts notice on behalf of 2 and 3. Mr. S. P. Das appears for his point number 4, 5, and 6. Ms. R. M. Barua for the point number 7. Who's for 1? I don't know. Mr. A. Gupta accepts notice on their point number. This is the matter of post to enable the respondents to file the record. What is wrong, madam? Madam, when was this wine shop transferred to that place? When did it start operating in that area, in your area? Huh? It has already been shifted, correct? Prior to shifting, there has been still like okay. The earlier one shop which we were holding, that part, the PRC of the PRC was disposed of, we are directed to locate that premises by the end of July. If sometimes different business activities. Now, maybe, supposing one wine shop is supposed to be open in some locality in Patti. All the residents of that area need not be. Yeah. 75 meters off. From the residence. No. Right? Well, there are. Give me that. When SM 290. 295. 295. Yes. For the purpose of 289(1), 295. And 295. Section rule 295. 295(1). 1, yes. 295. Roman 289 minus 295 1 and 295 2. Objection from the owner and occupier and residents of the neighborhood located within radius of 75 meters of the premises involved shall be considered. I am within 75 meters. It does not mean each and everyone. If there are 2 lakh people residing in that area, you mean to say all the 2 lakh people have to give their no objection? So I have made something before the DC minor. They have something before the. For the commissioner, well, your residence, your residence is within 75 meters. 75 meters of the premises. But this does not mean that each and every person. Doesn't mean that 100% has to give their approval. Is it? So it is for you only, or is it for everyone? Is it a public interest litigation? Further, there is a school located within 120 meters. This court has said no already. Yes, they are factually wrong. The site structure is on that tree. However, paragraph number 3 of the list, they say that there is an already existing one structure. Due to the demand in that area are likely to be shifted from the town to that area. The earlier education of the observed that as regards the from the school, the highway that was properly taken up by the commission. On Tuesday, okay, that's when we are trying to discuss it. Then when this there is already another wine shop there.
Madam, we did, there are 500. Then we don't reach 75 meters, madam, because I was telling you, stated, madam, if one thing is going to open, we need 75 meters.
And the other wine shop is not 75 meters from the huh?
I have five. That is
Alright.
what I know.
May have a detrimental. Actually, may have that is there.
So, but as per my instructor, madam, on the front side of the wine shop, madam, is
Madam, where is your residence? What is your house number?
either, pair of two, madam, is 5. Measuring minus 1, but from 5 times.
Huh?
Like, first time, madam, pair of 2. Part 1 village, and open for second. 1 to get and forward, back number. Because better number 1.
Should we send it to the excise research representation? Let it just be decided. What they are not even protected by. If they find that everything is correct, what is the you process? Right. Heard Mr. Kushal process for the petition. Also heard Mr. N. Yes, Mr. A Patra for five number 5. The issue hearing is with regard to the challenge made to the relocation of a white shop in the neighborhood of the petitioner. The petitioner states that the distance between the wine shop, the proposed wine shop, and the residential houses that the petitioner is within the prohibited distance of 75 meters. In terms of Rule 295 bracket Roman 6 4 of the Assam Excise Rule 2000. As such, the wine shop which cannot be established in violation of the rule of 2000. The petitioner of the subject that there is a pending representation dated 9/5/2015 issued by the petitioner number 1 to the respondent number 2. Huh? No, only one. Okay. No, only one. You have to think 19. Huh? It's kind of late. There's only one petitioner. What we have signed as to the letter they say I. No, you see, Noor Hussain Mandar is petition number one. The petition number two is Jal Hussain Mandal. Jal Hussain Mandal is not nowhere there. Yes.
That's papa.
Okay. But how does it matter? Right. Huh? It's a petitioner. It has not been decided thing. Petitioner started something. That the writ petition can be disposed of if a decision is taken on the petitioner's representation. And perhaps with some second. The counsel for the respondent, on the other hand, submits that, that there is no violation of the assignment statute 2014 with the proposed relocation, with the proposed establishment of the petitioner's relocation, okay, proposed relocation of the petitioner's IMFL office. They also submit that the present writ petition has been filed on the same issues that had been decided in relation with the Alakpura Popular Senior Secondary School relating to, in relation to the order dated 29/1/2024. Passed in WPC 1175 of 2020. And order dated 29/1 and an order dated 5/5/2025. Passed in WPC 417. 417 is 29. 417 is 29/1/24. And the other one 5/5/25 is 1175. Ah. Right. The the counsel for the respondents of the subject that the petitioners are well aware of the existence of another wine shop in the neighborhood, as has been reflected in para 3 of the petition, and that they cannot make a challenge only to the petitioner, to the proposed wine shop of the respondent number 5. They have a submit that the respondent, they have a submit that the petitioner's representation can be discussed by the respondent number 2. And the processing of the respondent number 5 should be completed thereafter. Correct. I have tried to learn fast for it. In view of the submissions made by the counsel for the parties, the respondent number 2 is direct take a decision on the petitioner's representation dated 9/5/2025. Within a period of 3 weeks from the date of receipt of a copy of the document. So 3 weeks is today second. 3 weeks, huh? Thereafter, the respondent number 2 shall ensure that the processing of the petitioner's relocation of wine shop should be completed depending upon the decision taken by the point number. These questions are accordingly discussed. Where is that? Page? I see. 71. And they have been this 51 is thereby notified that any prospective bidder who has entered the statement and are having pending proceedings. Okay, like, we have finished one move, that move, and as well as the close elect, not close elect, okay, is 227. In respect of the that move, so the move of the same, I think you to achieve the move. And nothing to say that because of that, or that move, okay, but in respect of phase 2 to 7, regarding the clause 11, clause 11, that is, I have, because in this clause 11, earlier also all the tenders, this clause is there. And in this case, against the state tenders, the petitioner participated, and they got
Clause 11, 2 to 7.
yes.
Grant bidder.
No, yellow card is not like this time. Yes,
Huh?
yes, yellow card.
Grant bidder.
Yes.
What does it say?
In case after 5 feet open to the likely opening the lowest available bidder is not awarded the job for any mistake committed by impeding or withdrawal of bid or modification of bid or varying that any term of illegal thereof, leading to retendering, individual shall forfeit EMD if paid by the bidder. And
What is PBDL? What is PBDL?
Yes.
Huh?
I am appearing for that. That is the
Respondent number 3.
yes.
Who is the respondent number 3?
Yes.
Huh?
Go ahead, the guest, okay, supposed to be guest, 5 guests. Shall forfeit EMD if paid by the bidder and sub-bidder shall be debarred from participating in retendering of the same job. Further, sub-bidder will be put on work slip, yellow card for a period of 2 years after following the new procedure. However, during the period in work slip, sub-vendor will be allowed to participate in all other tenders and to execute other ongoing order, contract or new contract order. In case of subsequent instances of default in other tenders during a post-work slip period, the action shall be initiated as per the provision of so yellow card will be automatically revoked after a specific period unless the same is for 30 people. The same clauses are also earlier also here, and the petitioner participated in the same tender and they got the work order. So in respect of the debt clause, I have the office. But regarding the roads, I have nothing to say because also they allow the people to participate in the tender and respondent shall proceed the tender without invoking that. And this but that will not be state. Huh? Clause is a clause. I'm not asking.
You are only asking to participate.
But if I have to state this inclusion. Only
And to say the
you know.
if you know, what no?
Only that state.
If you are only there.
The other one, allow the corporation to proceed the tender of not by not including that.
Is there any order passed by the court with regard to this?
Yes. That petition is pending. I have filed it with.
No, I'm not on that. Is there any decision taken by this court with regard to this clause? No.
I think because the earlier tender,
No. I think I have passed a decision in a different matter with regard to a note like this type. That is what I'm asking. I think there's a decision taken.
Clause cannot be. But I think I person intention is that
No. I think there is a decision taken by this court earlier. No, that's not. I'm not on that. I want the specific judgment, the specific other part.
there is the Supreme Court judgment. Still they can go with right.
Correct. No, I think this court has passed an order which is to your benefit. That's what I'm trying to get at. Huh?
I
This I will say, that is, no, I'm thinking of, if that decision was that they could have been disposed of people.
I am making there only one extra.
That means, I'm feeling sorry for the petition. Assisted by Ms. E. Khan. The petitioner found that the important note to be 351, huh? And they ran with a uh, clause, they ran with a clause, huh? Which is, which are as follows. This is a page 227. Okay. Bottom to there, 227 to 2. Should be state. Should be capitalized. In as much as the clauses are restrictive to nature and in violation of Article 14 of the law. Next paragraph. The important note to be and clause 11 bracket grand bidder are reproduced here into the page 51 and page 227. Okay. Good job. Next paragraph. The petitioner stop. That in view of the petitioner having filed WPC number
Number 1068.
1068 of 2024. 2025 against the respondent number 126. The petitioner's bid would not be considered for evaluation. In terms of the present tender notice dated 16/5/2025 for procurement of PE pipe. Accordingly, accordingly, topics that are important note to be is arbitrary. The same is the state at the state and the petition is the last participate in the tender. If you notice, it's another name. Oh, everything is going to be delayed.
My prayer to allow the respondent.
That's why because final decision I'll have to say. Okay, if you notice it's available in 4 weeks, Mr.
I am making for reference.
Okay, correct, the for fund number 1 to 3. Only 3. Who will pay for 1 and 2?
That is consultancy.
One, 3. Okay. If you, petitioner takes them for further notice upon the responding number. So just say 4, it says 3. Respondent number 1, 2, 1 and 2. Within 2 days. Who appears for, Chief Secretary and Commerce Department? He's not here. Have you served a copy? Who appears for Chief Secretary? So who? You're not the government of Assam, who are you? Mr. G. Bokalia, elected notice of the response number 4. And 5, industry and commerce. While Mr. A. Kalita, except notice on the response number 4. Now 5. This is the matter on your date. In the important note to be. Oh, that's all, huh? Yes. Say the major thing. As the petitioner will be allowed to participate in the test. Okay, there, okay, just say, just cut that, just say. On considering the case, on considering the fact of the case, the petitioner is allowed to participate, should be allowed to participate in the tender process. Tender process pertaining to tender dated 65/2025. And the respondent should not invoke the important note to be. Till the next, that's right.
Hello.
Oh, one.
For non-payment of
Okay, Mr.
PD.
PD Bhuyan, counsel for the petitioner submits that the contractual dues of the petitioner amounting to rupees 45,84,947 as not equal. To notice, it's under the service, the Tara Kuwait except notice on behalf of others. Other authorities, the matter of service to enable the response to further. Mr. H. Ura Gohain on behalf of Mr. BJ Mukherjee submits that the vehicle's higher charges of the petitioner are not be paid. To notice it's unable to service, Mr. E. Bokale acted notice on behalf of 1, 4, and 5, while Mr. R.K. Buchari for point number 2. What about 3? Mr. P. Bogoi appears for point number. Respondent should file the affidavit to this post. What about 6? 6 then. 7? I will. Mr. A. Dekha appears for. Huh? Mr. A. Dekha appears. No, Mr. A. Dekha also for the petitioner submits that the petitioner vehicle higher charges are not paid. If you notice returnable info, Mr. G. Bokale accept notice on behalf of all the respondents. This is the matter of the police to enable the respondents to file their affidavit. That's it, the first. Mr. M.A. Mr. M.A. Islam. Notice that the petitioner's contractual dues have not been paid. Notice returnable in 4 weeks. Mr. P. Bogoi accept notice on behalf of all the respondents. Petitioner, respondents to file their affidavit within the post.
No intention of not paying.
Huh?
I don't have any intention of not paying EMI, but then we are going for very hard financially. Well, our shop has been structured by the builder and it's under completion. They are really running calculated course for the every day like this. And this thing they had also informed the bank concern. But the bank were getting them, waiting for cycles. They would also take away the house, auction the house.
Madam,
How
you
they-
have not paid
But
your loan amount, correct?
but not pay. Get rid of the cash. And they are making, I just understand, them understand that why are they creating a fair cycle?
Madam, it's not a question. If you don't pay,
No,
you cannot say that you're supposed to pay. You are at fault. You cannot say that they are at fault.
they are not
Then,
the house. They are nobody doesn't pay the pay for the vehicle, with the vehicle, there's a
when will you pay?
they're just giving 1 month. And document on the 15 days.
Who is for the other side?
There's 6. And second take on. That's one number 5 and 6. We have to annex our financial crisis. 30 to 4. All everything. Basically, the bread run of the shop is under construction. And with this, we have also approached the bank. This is our financial state. We are going to give. We are just give us some time, months time. And because one vehicle is already was in the news that it was taken.
Madam, this, you see, it's not that.
Trying to think that they have also lost that car. It sold out one time such a one. And which they put under them, then they not on at all. Instead of the shop, they have to start like a. Praying that will not pay, but reasonable time. Come up with it. Already given the 29 for the representation.
Madam,
6.
you see, the only thing is that we have been talking. Main submission. Please look at page 28. Come to that, please read the last paragraph. Therefore, please read it.
Common target. Give first, second part, providing. And it's the example.
What, which page 28 are you reading? 28, 28.
Without figures. Thereby, the publicity.
Huh?
They
Madam, please, what have they said out here? In page 28,
entire of the part. 6 of from the date of. Start considering. Right. Right. Public auction, private. Or
so madam, you have been asked to call on them by 6th June. Today is 2nd of June. You have got 4 days left. Have you made any representation to them? Where? Now, just a minute, this letter of this page 28 and 27, part of 27, is of 22/5/2025. Now come to the, madam, come, let's see your representation. Which date? Your representation, April. Madam, this notice is of 20, is of May. So, you go to them, they have asked you to come and appear before them. You're not going before them, you're coming to this spot. They've given you time till 6th of June. You go to them first, file a representation to them. What do you mean that will do? You have got to do it. They've asked you time, they've told you, call upon us. What do you mean call upon you means what? Instead of calling upon them, instead of filing a representation, submitting a representation to them, you come running to this court. You go to them first. Yes, okay. Yes, madam. Let her file a representation, you consider it. Okay, till then this is mistake. That's it. Please, at least you see, for us to take some kind of action. Just a minute, listen, madam, please listen, please, just don't speak all the time. Okay, you've got to listen all. So the thing is that since you have not taken any action on the letter of 22/5/2025, you can call upon them, you can write a representation to them and let them decide first, and then you come to us. Not the other way around. Right. Heard, miss? Just a minute. First.
Section.
Just a minute, madam, I've heard you. You have used the word fierce psychosis, I think 10 times already. Miss, what is your name? E? Sinha. Miss E. Sinha. Appears for the petition, counsel for the petitioner. Submit. That. The petitioner has defaulted in the payment the of EMI for availing loan from the respondent number 5 and 6 for purchase of commercial vehicle. He submits that the petitioner has been unable to pay the loan due to losses being suffered by the petitioner, and submits that the entire loan amount would be paid within 3 months. That's what he said, 3 months. He, however, submits that in terms of the notice for seizure of hypothecated assets issued by the respondent number 5 and 6 on 22/5/2025. The petitioner is to pay all the overdue amount by 6/2/2025. Next one. The counsel for the respondent number 5 and 6 submits. No representation has been issued has been submitted to the bank by the petition with regards to the submissions made by the counsel for the petitioner to the. And as such, he has got no instructions with regard whether 3 months' time can be given to the petitioner for repayment of loan amount. I have heard the learned counsel for the. A perusal of the notice for seizure of hypothecated assets dated dated 22/5/2025 shows that the petitioner has been requested to call upon the respondents number 5 and 6, the petitioners, yes, to call upon the respondents, number 5 and 6, and to pay the entire overdue amount. by 6/6/2025. However, the petitioner has neither called upon the respondents number 5 and 6, nor submitted any representation to them with regard to their intention to pay the entire overdue loan amount within 3 months. On considering the above, this court is of the view that the petitioner should submit a representation to the respondents number 5 and 6 with regard to her proposal for payment of the entire loan amount, overdue loan amount by within 3 months. The respondents number 5 and 6 shall thereafter. Just for minute, what is this? Number 5 6 shall thereafter take a decision on the petitioner's representation after giving an opportunity of hearing, personal hearing to the petitioner. The, the petitioner is accordingly directed to submit her representation to the respondent number 5. To the respondent number. This letter is written to you by the Chief Manager, Bangagar Branch. To the respondent number 6. Okay, to the respondent number 6. Within 4 days from today. That is on or before 6/6/2020. In the event the petitioner submit a representation before the respondent number 6 on or before 6/6/2025, the notice for seizure of hypothecated assets dated 22/05/2025 shall be kept in abeyance until a decision is taken by the respondent on the petitioner's representation. The representation is accordingly, the petition is accordingly.
And
This is a dispute between two private parties.
private party number, but the commissioner, and for that, my lord, we have approached the chief commissioner, that is at page number 34, ma'am.
Why don't you go to civil court? This is a civil court. It's not a race. This is not a case for race court. Between two private parties with regard to rent.
Yes, because it's of the tower, we have approached the commissioner, then commissioner sent a notice to the private party, so that's the page number 30.
Yes.
Page 36 and actually.
You see, they are not a court. I'm not going to, you go to the civil court. You cannot come with dispute to this state court. Opening tower, paying off, what is it? Pay the outstanding area amount to the petitioner. I do not know if the district deputy commissioner can pass that order. Can he? Huh? Ah, you withdraw why they are dismissed.
Maintaining of the tower.
Huh?
We are not saying that getting maintaining of the tower.
You dismantle it. You dismantle it. You dismantle it, you pass on, charge them the cost for dismantling. This court is not going into those issues. You have private issues, you go to the civil. I do not know whether the ECL got the power to do all this. Okay, what is your name? In the fifteen case. Mr. Ikemazutta. Run off the policy. The subject, that's the petitioner, is the absolute owner of a plot of land. From out of which a portion of land measuring 50 by measuring 2700 square feet was given to the respondent number 2 on lease for a period of 12 years to be computed from 1/6/2007 to 31/5/2009. Now, who informed you? You said on 20th July 2020, the respondent authority. Which authority? Which authority informed you?
Page number 29.
Para 4, you said the respondent authority. Who is this respondent authority?
Three.
Respondent authority it's a CNI, it's not it is also a private body. Yes, it is that authority, not an authority. You're right. The petitioner's further case is that the these periods for the land between the respondent number 2 and respondent number 3 had ended. And in this respect, the mobile tower that had been erected by whom? By the respondent number 2 and 3 was to be dismantled. However, the same not being dismantled. The petitioner approached the office of the Deputy Commissioner Lakshipur for a direction to be issued to the respondent number 2 and 3 to dismantle the mobile tower and to pay the outstanding area amount to the petitioner. Next paragraph, the petitioner that by letter dated 21/6/2021, the deputy, the additional deputy commissioner wrote a letter to the respondent number 3. No, okay, wrote a letter to 1 MS GPL Infrastructure Limited to dismantle the mobile tower and to pay the petitioner his outstanding arrears. The petitioner whose count is subject this para that the respondents have not acted upon the letter dated 21/6/2021 issued by the additional deputy commissioner Lakim Table. They accordingly submit that a direction should be issued to the respondent to demolish the mobile tower constructed over the land of the petition. Next paragraph. On a bare perusal of the writ petition, it is clear that the dispute raised by the petition pertains to a dispute between private parties. Further, the letter dated 21/6/2021 issued by the Additional Deputy Commissioner has been addressed to one MSGTL Infrastructure Limited, which is not a party in the present petition. Goes down. Huh? Which one? Which is this point number 4?
Yeah, man.
Huh?
Yeah.
Who is this point number 4?
The branch manager, ECNIL and PL, they unite with their pilot. That is, and except the mallet.
Anyway, cut that last. And in any event, the present case being a private dispute between the parties, this court is a review that the petitioner should approach the civil court. As no legal or fundamental right of the petition has been violated. Accordingly, the writ petition is dismissed, with liberty being given to the petitioner to approach the appropriate court, approach the appropriate civil. As per law. I don't.
By this, there is a date for submission of tender, but this case is I only think.
No. Why should I issue notice like that? How are you challenging the, and I think, what ground?
Page will of 85. It's bill mean mahal minor. On highlight of the settled for speech number for 7 years.
Yes.
It was not the possession of the bill was not handed over to the prisoner. Bill to one settled by on missing of was counsel to the other person. So in the meantime, he has suffered to be lost. He has to file petition to the authority for remission of something.
Mr. Council, come to page 83. Your earlier writ petition, 82. Yes. Now your memory job. Come, please, come to para 6. Please read para 6.
It has made a medical director to have to notify the sponsor, informative the balance sheet amount of the sponsor for a period of total amount of the period, like 59%. Here is possible if it's not therefore was directed to the daily settlement. When a party petition will be recovery as well as the cancellation order was tenant, which is pending.
Now, you see, when did the missing autonomous council settle the fishery with somebody else?
Yes.
When? Why is Mr. P. Sharma not here? Yes, when? When was it settled with somebody with the?
Well, it is regarding earlier the request was filed before the directed matter, case 44 matter. Is 44.
Yes.
Property part is page is my lot 45. The last paragraph. Considering the fact of substance of a case as well as the materials available records, the that has provided that if it is not police one forward, that shall not be picked up in any manner in the account. Granted, my lord, our court order over there, but it was not.
You see, it has settled a part of the fishery, not the entire fishery.
That is like it is about loss, my lord.
So that issue will take care. If there is that We do not know if what you're saying is the gospel truth. We do not know. So even if it is true, it has only a part of the fishery had been settled. So that can always be adjusted. The fees can always be adjusted. That is no ground.
I want to,
Mister,
you know,
we Raman, not part of the petition. Says that is not allowed to be taught the petition. Mister, he will go appear for missing autonomous council. While Mr. MTT appears for 1,067. The affair of the petition counted as allowed, this petition is dismissed as. Yes, paid. So the instructors then,
so that I work with the company, so just continue.
not paid.
No, please, I think, pay the time.
So he said that paid. Once it's paid, then nothing remains.
Let it be on record.
Okay, right. Mr. R. Sharma appearing for the petition, Mr. D.K. Roy, learned counsel for the FCI. How for?
Yes, phone number
225. Submit that the
to the
provident
bank,
fund dues have been paid by the petitioner.
it was recovered to the bank. The bank.
So, on the other hand, Mr. Speaker, Roy submit that the PF dues have been recovered from the petitioner through the bank. And in this regard, he has submitted a letter dated 5/5/2025 issued by the branch head, Axis Bank Limited, Itanagar branch, which states as follows. The letter dated 5/5/2025 issued by the branch head, Axis Bank Limited, Itanagar branch, is made a part of the report and marked as an exhibit. In view of the submissions made by the council for the party, and in terms of Annexure H, the petition stands closed. Become infrastructure. That's what. This,
Please correct. Correct. Not
Please, Karande, appearing on behalf of Mr.
put it working.
Biri Cover, learn senior counsel for the petition, submit that the matter has become infected. Mr. R. Roy appears for the excise department, which petition accordingly, this is the report.
Bulky affidavit is there, and we
It's
have,
the thing is that the issue is very small, it's very bulky, that's all.
we have also missed my lot that, missed my lot, we have, almost we have missed it, but I took a fast chance, my lot.
For what?
For filing of affidavit,
What affidavit?
because my lot, the amount, whether I will receive that or not, my lot. There is a thing, my lot, please, payment of bill for construction of road. And also in the one part of the matter, equity is not maintainable, they are selling. That part also we have to apply, but only last chance of one. Now, 1 week maybe, only one. The payment of bill, otherwise the petition are my lot will. Because there is no state or nothing is there, only nothing.
In fact, you have to pay the respondent.
There is a, there's no reply, my lord. I am a contractor, my lord. How can I?
Because you did not complete the work, and they
Yeah.
had to do the, they had to
Getting
complete the
paid.
work by third
They
party.
say during my lord, that COVID, Coping time.
You see, is there any arbitration clause here? End of the matter. If there's an arbitration clause, you see, this issue is,
That also, madam. I agree, madam.
this court cannot decide.
Okay, madam. Just one week, madam. I just reply to it, madam.
You
Then
you-
your
you
lordship
reply
may-
what?
Told them. Against the affidavit. They say that I have to pay rather.
Yes, you have to pay. I don't,
I am a contractor, my lord, but I, so just reply.
you see, because your contract agreement provides that when the contractor does not complete the contract work and it is done by a third contractor, then the payments that have to be held out to the third contractor
It is
is to be
something
borne by you.
And I was the finding for. Sir, one.
I am not going into that.
Okay, my lord. Then if arbitrator also, my lord.
Yes.
Only one with the record I have to entry. I will entry some record there.
Okay, we'll give you by Monday.
Yes, my one.
Monday, next, by Monday you
Yes,
file
madam.
your affidavit. I'm dismissing it. I mean, I'm closing it. Because you've got nothing here.
Yes, my Monday. I have to keep
You
some record.
you want it to be on the record.
That is the thing. Because I have to deny it. They say to rather I have to pay. To deny it. Otherwise, I ruin my lord.
I affidavit of 2019 December.
It is of course.
I know.
the government. Nothing is moving from the government. I have to.
No, but
I am a citizen, man.
you're a citizen causing trouble to the court.
That is another. They are the.
We are trying to dispose because of the huge tendency of cases all over India. And you're not helping by saying that you want
Just one word. That one word.
6 years have gone by.
Last 4 time date taken.
No, I'm going to fix the date. I'll say no further. I'm going to write everything now. Don't worry. Right, Mr. Bharat Kafe for the petition. And Ms. P. Sharma, TDC, for all the respondents. Right, next. It is a problem is we have to read a thick file. And the issue is so small.
I don't know how to contact.
Otherwise, it's a very, but then I have to read. Now, if I,
That is the, I cannot help follow your lordship now. That's all. On Monday, your lordship may dictate the order.
or
Monday,
Friday, this Friday,
Yes, final order.
this Friday.
This Friday. No, but I'm saying one day, bulky evidence I have to find, man.
No, don't have. You just have got to,
Okay,
write against para 3 and para 6 of the additional affidavit
Then your lordship
and
order.
para 23. That's all.
Okay, man.
Nothing else is required.
Okay, man. Okay. Next Friday, my lord.
Not next Friday, this Friday.
Yes, this Friday.
Whatever I said. Okay. The petitioner has prayed for a direction to the authority, for a direction to be issued to the respondent to release and make payment of rupees, no, to make payment of the bills in relation to the following work orders, which are as follows. Page 9. Okay. Make it 1, 2, 3, 4, 5. So the work order and the amount. Work order amount. Next one. The affidavit in a position filed by the respondents number 1 to 4 is to the effect that despite issuance of several notices to the petitioner for completing the work, only 52.58% supply has been made by the contractor, despite a lapse of 20 months. Though the supply had to be completed within 180 days. This caused inordinate delay in completion of the work, ultimately causing time and cost overrun of the project. Thereafter, final notice was issued on 27/8/18, and it was decided thereafter to cancel the work orders on account of the petitioner's default under condition 28 of the general conditions of contract. Accordingly, the contract agreement was cancelled at the contractor's risk and cost by letter dated 22/9/2008. So the payment of rupees 7,07,237 against work done was only for 52.42%, after necessary deduction from the gross work done value of rupees 10,45,380 already paid to the contract. Next one. The additional affidavit of the respondents number 1 to 4 at para at para 3 and 6 really goes to show that the entire work got completed by concluding risk and cost contract under CA number CDR 24TF-07 of 2018, 19, and Pusta. And para 6 and page 290. I think it's para 6. Para 6, para 7 also, para 6 and 7. And para 8. 292, 293. Okay. Mr. B. Sinha prays for 4 days time to file affidavit, additional affidavit against the affidavit in opposition and additional affidavit filed by the respondent number 1 to 4. It is seen that the affidavit in opposition had been filed by the respondents number 1 to 4 on 6/1/2020. And the additional affidavit had been filed on 17/2/2020. As the petitioner has not filed any additional affidavit against the above two affidavits, even after 2 years have elapsed, the petitioner is granted 3 days time to file additional affidavit against the above two affidavits of the respondent, failing which the matter will be decided on the basis of materials on record This is the matter of Friday. Right. 90%. You come to para 5 of the affidavit filed by them. Okay, then. Thereafter, I think the lordship, construction was, executive construction was. Kindly, it is a clerical hand of the executive. The prospect of the, it has been educated by, okay, you verify and pay. Never the, pass this. So can I say pay to? Why? Get the company. Why have you come then? Directors to take measurement and accordingly make payment. What is that? No, you come to, you see, you come to, I don't know why I have to spoon feed you, this is your affidavit. Come to para 7. Please read para 7. That with regards to state any kind of level. The estimate that it is up to the present for the work. Some progress of the work, the team does not exist to record the data. Then expect this by data. Some the work had to be everything without the progress of. So, there are two aspects. In the contract agreement, if there is a risk and cost clause, whereby an uncompleted contract is to be completed by a third party, and in which case you will be a default. That also can be looked into by him. Because he has not completed 100%. That's all. And if there is no risk and cost clause for non-completion of a contract, then he'll have, it will be paid for whatever amount he due. What else can be decided? Huh? Yeah. So let them decide. You, because I'm quite sure your senior country also won't know whether there's any risk and cost clause in the thing for completion of an uncompleted contract at the expense of, at the cost of the original contract. Right. Right, Mr. Sure. Huh? Sure. Please, Karma. Let us pass it for the petition. Also heard Mr. M. Bhuyan. Let us pass it for the PWD department. The petitioner. As case is there. The petitioner was allotted a contract for construction of a roadside drain with footpath at the Assam Engineering College approach road. It is the case of the petitioner that for reasons beyond his control, the work could not be completed in time. However, though the petitioner completed 80% of the work, 80% of the work, the petitioner has not been paid all his dues. So, for this case, only thing I was telling Mr. Mbuyan, is there any risk and cost clause whereby an uncompleted contract work, if it is to be completed by a third contractor or a third party, then that risk and clause he'll have to pay. Yes, that can be adjusted. Correct. Next. Mr. B. Gogoi submits that the petitioner work was duly measured, work done was duly measured up to December 2014, wherein he had achieved 59% physical progress of the work. The value of the work done amounting to 59% of the work was rupees 115.00330, some of which was duly paid to the petitioner. However, the work between January 2015 to February 2016 that may have been done by the petitioner, that was done by the petitioner, has not been measured as per records available. In 80% they have measured it. No. Please read their affidavit. This is not your affidavit. Has not been measured as per report of it. It's good stuff. However, the petitioner had left the work, had not completed the work since February 2006. Next slide. Mr. P. will submit that the respondents will verify the work done by the contractor, by the petitioner contractor between January 2015 and February 2015, and thereafter pay the petitioner the admitted dues in terms of the contractor dues. I have heard the learned cost for the contract. Para 5 and 6 of the affidavit in opposition filed by the respondent number 2 is to the effect that as on December 2014, the petitioner had completed 59% of the work contract and he had been paid his bills accordingly. However, there was no measurement done of the work done by the petitioner between the period January 15 to February 16. Further, the petitioner left the contract work in a standstill position, since February 2016. In view of, next, para 8 of the affidavit in opposition filed by the respondent number 3 also states that the jurisdiction of the work site is now under the West Guwahati Territorial Road Division after reorganization of the Public Works Road Department, wide notification number RBEB, post of 116/2019 PT, post of /1/32, dated 6/11/2019. And as such, the PWD South Kamrup Territorial Road Division, inverted commas, erstwhile Guwahati Road Division, that closed, could not submit the active status of the executive. So, next, in view of the submission made by the council for the PWD, it is clear that there is a dispute with regard to. It is clear that a measurement slash verification of the work done by the petitioner for the period January 15 to February 16 would have to be undertaken by the PWD. By the West Guwahati Territorial Road Division. Accordingly, the respondents are directed to accordingly, the respondents are directed to verify the work done by the petitioner for the period January 2015 to February 2016 through the West Guwahati Territorial Road Division, through the executive engineer, West Guwahati Territorial Road Division. And if the petitioner is to be paid, is to be paid dues as per the measurement done and in terms of the contract agreement, the same should be paid to the petitioner. The entire exercise should be concluded within a period of 3 months for the date of receipt of a public form. Be happy, Mr. Council, 2019 order, I am holding it out. One point of my case was, I was given 60 lakh, 80 lakh. Look, you see, these are all disputed, these are disputed questions of fact. Actually, you are supposed to go to a civil court. Okay, what you write, huh? I was paid, okay, right, the petitioner's counsel submit that the petitioner has completed 80% of the work that and full stop. However, he has been paid only rupees 60 lakhs, 60, comma, 1 to 15 lakhs. Because 89,000 is the claim I was arranged for 1 to 15 lakhs. So how much have you been paid? 60 lakhs. I entered for 6 lakhs 89 lakhs. That is for the entire contract work. But the entire contract is 1 to 95 lakhs. I was paid 1 to 15 lakhs. 1 to 15 lakhs. I entered for 60 lakhs 80 lakhs. Okay, just say. The petitioner was paid rupees 1, 15, 00, comma 320. And he is still to be paid an amount of rupees 60, 89, 280. According to that is his example. That should be that's according. The other provision to repeat the payment. We have negligence. You see, these issues, so you go in arbitration, if there's arbitration, or you go to the civil. We are not going into those issues. Sorry, Mr. Counsel, this is not a court of evidence. Can you be after the pen? 95% work completed. That's the okay, how much time? After no affidavit. Not required. Mr. P was talked about the PWD granted 10 days time to file affidavit. This is the matter of that.
This case, last week is under 28.
What is your case? What is your case?
So in this case, I have not given the site note.
You have not been given the site.
So I
So
have,
no work order.
I have, what about this?
Work order is there, but no site given.
Site given.
Huh? No site given. Site,
Some part of, given, but
did you do any work?
yes, sir, I have completed the work, the first site given.
Yeah.
I have
You have
completed.
said the site not given, but how can you complete the work?
Yes, but the part was given, part was not given. Part was given, if you instruct, I was given the.
Yes, madam, what is to be done here? I don't think 20 years back, I mean, not 20 years, 2020 matter. Of course, it has come after quite a few. If we'll call the chief engineer. Huh? See, I don't think 20 years, 2020 matter. It's not done. Right. The writ petition have been filed claiming payment of contractual dues. Correct? Contractual dues.
Security then finalization of the contract. As you know, the authorities failed to launch it, and over the start launching. So I could not launch it,
The petitioner has, the project petition has been filed on 12/3/2020. Trying to finalize the contract with the petitioner, besides releasing his contractual dues. No affidavit has been filed by the respondent even after 5 years. One last chance is provided to the PWD to file their affidavit, to the GMC, failing which no, by the next date, failing which the Commissioner, Guwahati Municipal Corporation, the Commissioner, Guwahati Municipal Corporation, and the Chief Engineer, Guwahati Municipal of Corporation shall personally be present at 10:30 on the next day, along with the concerned department. This is the matter of, where do you want? 30. You tell them, if they don't come, they have to be here. Otherwise, I'll ensure that, they are blocked. Yes. This is not. You bring it, show me. It will say, so have you spoken to your client? When did you speak to your client?
no,
Huh?
it's taken to withdraw, but that, oh, then.
So we will record it here.
With suspension of the order, but they have. Keep finalized.
Okay, till finalization, what is the question of finalization of this? That is the issue to be decided by you. How can we decide?
Because only the.
No, is your, are you planning to suspend or are you planning to cancel it or,
One is you don't have.
yes? Because this is only a order suspending. They will close it like this. They will not, if they come, if they do something, come away. Heard, Mr. Then how, call it for the petitioner. Also heard Mr. MPC, then call it for the petitioner. The petitioner has put to challenge the impugned order dated 11/5/2020, by which the petitioner's fair price shop license has been suspended by the authority. Mr. M. Chetty, then counsel for the all the respondents submit that an affidavit has been filed by the respondent number 3 on 22/5/2025, and it has been clearly stated in the affidavit that the suspension order of the petitioner's fair price shop right has been withdrawn. While order dated, no, right, when, I think, no, that is, while 6/11/2020 issued by the deputy commissioner, by the deputy director, FCS and CA, Chirag. Next para. Para 8 of the affidavit filed by the respondent number 3 is to the following effect. Take this up, huh? Have you got the filing number of this? Following effect. In view of the suspension of the petitioner's fair price of license having been withdrawn by the respondent, nothing, there is nothing left to adjudicate in this case. Accordingly, the writ petition is closed as referred. Both. Suspension order has been suspended. Yes, no, that is all right, but what about you? Right. Mr. M. Pete is granted 2 weeks time to obtain instruction as to whether the order dated 20/06/2020, by which the petitioner's fair price of has been suspended, has been withdrawn. This is the matter on. You. Already in the first case in the elected item, in item 19, it says registry to place the affidavit of the respondent number 3 in the report. Huh? That's the first date, madam. You have said that you have not served extra copies of the writ petition. Now, what is to be done? Miss, what is your name? M. Das, appearing on behalf of? Appearing on behalf of Mr. Bimanta. Bimanta, Learned Counsel for the petitioner, submit that she will serve extra copies of the writ petition to Miss B.S. Neo. T.S. T.S. Neo. T for? Really, T.S. T.S. now. Learn counsel for the respondent. The matter pertains to non-payment of contractual fees. List the matter after 4 weeks to enable the respondent to file the debt.
But when appearing on behalf of each arbitration. That is each arbitration. It kindly adjust the
No adjournment. You, tell me what is the case about?
get taking novel payment of wages conflict. The petitioner working under resolution number 5, we take versus contractor and work order was passed against
Madam, what order are you challenging? Or what do you want in this petition? Let us see, what is your prayer?
the petitioner pay before the labor of their lordship for payment of their wages. The fair petitioner on 2515 lordship. Case number 15 lordship.
Yes,
They are paid for the labor of lordship. Accordingly, officers make and remind the elector bill lordship page number 17. Whereby
page number?
page number 17 lordship. So it is concluded that the lordship hereby conclude that the complaint is genuine. Afterward, labor commissioner Soraideo write an application to the chief engineer, the executive engineer PW for release of the payment. This is page number 22 lordship. Come to page number 25, annexer E lordship. Hereby, engineer executive engineer PWC write as per instruction of chief engineer PWC road, Assam Salmari Guwahati, you file letter number so and so dated 1/3/16, the sum of which 932,245 is recovered from the contractor. Three, so and so, from his ST retention money from workers under ticket number AS 178 for payment of unpaid earnest money and wages due to deposit, proprietary and 7 others. As per provisions under section 21(4) of the contract, labor act 1970 laws. But still, lordship, this amount is also not paid to the
What is the amount to the pay?
19 lakh. Unpaid amount lordship 19 lakhs 96,266 rupees.
To be paid by whom?
Paid by the contractor, respondent number 5 lordship. Respondent number 5
Respondent number 5 has to pay you.
lordship.
On the basis of what? On the basis of a letter?
Lordship,
What?
respondent number 1 was engaged by the contractor, that is respondent number 5, or as a mohori or in charge of his
Who
contraction.
is respondent number 1?
Respondent number 1 Respondent number one, I'm thinking about petitioner number one, logic.
Petitioner number one, was engaged by,
So the petitioner number one was engaged by the respondent number five. He is a first class contractor, and respondent number two had issued work order. The work order.
work order to whom?
The respondent number five not. And the petitioner number one also engaged another five labor. For each
So
one.
you also engaged another 5%. So you are also laborer. And you're not getting paid by the contractor. I don't know. I don't know. He's saying that you have to pay.
By one minus Gamburu Vishad, taking that minus by court signature. The Davis Motimotari was claiming some money.
Final report was submitted.
Come to page 43. I don't know. This labor officer has directed you to do it.
But we cannot realize it from the particular subject. So there is some transfer can be done.
You see the privity of contract is between you and that contractor. You did, what kind of work did you do? What contract work was it?
What is road construction?
Road construction. Now you're not working anywhere. Who is for the contractor? Anyone for the contractor? Very difficult, madam, very difficult. How to do? The work with the people, right? And this is a salary issue between contractor and petitions. No. They have been adjourning this matter time and again. That is why your senior is not coming. The senior is in which court?
He's not go to my report. He's not in the go to my report.
Where is he?
Actually, he's in the Department of Higher Education office today.
Okay, what is your name?
At the other
Huh?
At the other side.
Please say Talukdar appears for the petitioner and submit that the petitioner was a laborer working for the respondent number 5 who was a contractor. The respondent number 5 had done contract work of construction of a road for the PWD. And as the labor officer had directed the chief engineer PWD to had requested the chief engineer PWD to realize the amount payable by the contractor to the petitioner. The same should be done by the chief engineer. This is a request by a letter, not even a thing. You're right. The Ms. A. Talukdar submits that the matter may be heard on another date as a senior is having some personal difficulty. List the matter tomorrow. Tell your senior to come. List the matter tomorrow. Yes. for the time being.
Okay. What the PFP mandate you will pay by number
Huh?
124.
What?
For what you will pay. They will need a-
Yes. Who, 124, who was the earlier council? With the 3,000 income.
He has a- there is some talk going on in the department allocated itself.
Yes, yes, sir. So we adjourn the matter. They stay order in against you. And they want some time adjournment. They want adjournment. No problem, I think, since there's no stay order. You're right. What is your name? A. Ahmed, Learned Counsel for the petitioner, pays for adjournment. On the ground that some amicable settlement talks are being carried on. Mr.
And
M.
over.
Gogoi, ये file वकालतनामा?
No.
Submit that he will be appearing for the respondents number 1, 2, and 4. And wakalat number will be filed within,
Tomorrow.
will be filed within 2 days. Accordingly, let this matter when? I don't know, when do you want? This is the matter of 2.
Okay.
Can we do the others first? Finish out all the others? Yeah, can we, I think better we dispose of all the other matters and then we leave. We do yours at the end. Okay? I think we should finish by 2. We try to finish. At 2, we'll take up your time. Yes.
Hello, do we find the equity together? That the purchase some goods from this richer rate, Vanilla Dolpa. He has mother filed in 2000 years and through what I said, mother is I said before 49 mother. Sir has better the front of West Alabama finding the area. Which are lying at the side, which are lying on the important. And this is that. And we have purchased a $2,000 going to be materials for we have released that document. And it is verified by the opposite concern. It is prior to them. First order, they are not paying balance. Subsequently, we have not done anything. They are lying as it is. You know, 50 days, if you are malad. One, the final subject I think I am not in submit here the details of the report of $200. After basing on all the documents and stock of the same data unit of so and so. Stock of so and so, you already paid some materials are lying in the paper. The biggest point or other little break of the paper in the next
So these are also this prior to I annexed from the Salan also the separate for the page 57 doing up from for here minor level. He just separate for that he has made the from whom also I start from this. And you see this, you see a writ petition was filed in 2019. Yes. Now for the first time after 6 years, we have come and saying that we have bought. Why didn't you come up earlier with
In
it?
that also I had a technology. Because also team will get fired.
And you go to the Supreme Court, you go to the Supreme Court and ask for transportation. This issue is now lying with the Supreme Court. Why should we enter into the?
Your lordship see, my lord, this no court has passed orders, my lord. Because in so much money I'm wrong court, still this concern, my lord, Supreme Court passed order. Then another matter, my lord. Another matter we have submitted that order, my lord. Supreme Court has allowed, my lord. Supreme Court says that to go to the import committee, my lord.
Then you go to the empowered committee. Where are they say?
My lord, the lower income cluster, my lord, that is, I had submitted last time 7 7.
No, let us see where it is. Let us see the order where it says that we should go to the empowered committee.
So my lord, let's check that, my lord. Around 1.4 my lord.
Yes.
Any individual having any grievances against any steps taken by the government or any other authority in purported compliance with the order passed by the honorable court would be at liberty to vote the committee for seeking suitable relief. The committee may dispose of such application in conformity with the orders passed by the honorable court. Any application which cannot be appropriately disposed of by the committee may be referred to by to this honorable court.
So let me go to the committee.
If you want, we can go, my lord, and
My lord, your lordship see, my lord, that
Just let him continue. Just let him continue, but
yes, Lordship will look into my lord page 28. There is a specific order of the Supreme Court, my lord.
page 28 of the
It petition, my lord. That second paragraph, my lord. The Director General of Police, Assam, and the concerned superintendent of police shall also ensure that no illegal mining takes place in the aforesaid area
okay.
and no transportation of illegally mined materials take place from the Karbialong field. My lord, there is a direction from the Supreme Court about illegal mining, and the petitioner concerningly, my lord, we have filed the affidavit that it is the illegal mining. We have stopped that affidavit, my lord. And on the basis of our affidavit, my lord, we have given the undertaking in the Supreme Court that there no transportation or no illegal mining would take place, and those and no order has been issued for revival of those cultures, my lord. We have given the undertaking in the Supreme Court, and on the basis of the undertaking, Supreme Court, my lord, passed an order in the year 2024 that we have given the undertaking, and those minings, in particular in the petitioner, my lord, these two petitioners, we have given the undertaking to the Supreme Court that we have not.
Where is that?
My lord, that is the judgment of the Supreme Court, my lord. In our Karbialong, my lord. My lord, page 16. Yeah. Paragraph 2, in the affidavit dated to ensure filed by the state of Assam stated that the elevated corridor of approximately to ensure kilometer was proposed in wildlife friendly reserve. The project includes 3 elevated sections. This is in respect of state of Assam. In respect of Karbialong, my lord, paragraph 5. In the affidavit filed on behalf of the KAC dated 5/11/2024, it is stated that all the mining activities inside the Karbi Anglong district bordering the southern parts of Kaziranga National Park has already been closed pursuant to the meeting of the CEC. It is further stated in the affidavit that notice to close 32 stone quarries and 18 number of stone quarries as well as 18 stone quarries, which includes the petitioner, my lord, was issued. It is further stated in the affidavit that mining activities along the southern boundary and the catchment area of the river stream originating in Karbi Anglong has already been prohibited by the order dated 4/5/2019 passed by the Deputy Commissioner Karbi Anglong. The affidavit also places on record a letter dated 7/5/2024 issued by the Divisional Forest Officer Karbi Anglong stating that no new order for lifting the closure of the quarries has been issued. We therefore find that the KSC has also taken necessary steps to stop the illegal mining in the areas bounding TNP. We therefore close the proceeding in so far as these two issues are concerned. So, in respect of the specifically these two petitioners filed, that has been closed and we have filed the affidavit to that extent to the affidavit. If the any materials is lying, which is illegally mined, then they have to approach the CEC or not before this honorable court. And my lord, another PI was filed before this court and the PI also in this division bench has already been not entered in the PI, my lord. That was also order is there in the Rajiv Bhattacharya case, my lord.
What is the number?
It is Rajiv Bhattacharya PI and Rajiv Bhattacharya. Yeah.
Which year?
24. 24.
Rajiv, RAJIB.
GIP. Can you spell?
Rajiv Bhattacharya
This is my lord.
Bhattacharya
Also, my lord,
versus
versus my lord, state of Assam. When my lord, our petition at the disposal in the Supreme Court, they have filed a petition for the earlier the two different bench. RAJIP. And my lord, on 13 May, Supreme Court, but the Central Empowered Committee also issued a direction with this part, my lord. On Friday, my lord, we have another direction not to transport any illegal mining. When another application was filed before the. My lord, last my lord, conclusion, my lord, paragraph 9 page here, my lord.
this is the CEC order.
CC order, my lord.
CEC
Now,
order
taken
dated
35/2025. Again, by reiterating the order of the Supreme Court, my lord, and specifically asked not to transport any mining, material.
and this mining, this stone crusher is in the Kaziranga airport.
Kaziranga part.
Karbi Anglong area.
My lord, that is the particular unit of the petition.
There's no fountain. Okay, anyway, right. Yes.
My lord, your office, my lord, I have to take 28 of my.
Yes.
My lord,
The second paragraph, diagram of police are found. Confirm, ensure that no illegal mining takes place at protected area and no transport of illegally mined pillar. Well, illegally mined pillars, well, I have already submitted one order of this court final passed in 24 miles. It, WPC 771772. Earlier, earlier. So they were allowed to do both up. So what you see, para 7 page 4. Taking into account the orders which been passed in the outside, the concept that some like permitted take out the police for that, which are lying in the court of that. They have the first one submitted it. Removing out those measures, taken from first department, unless the court may be advised, if not, the court the concerned cases for due condition of removing these products. Hello. On this, except the orders from several partners that is allowed to remove the measure.
Those who are not allowed to take their, the petitioner approaches the concerned division and
Those, scope classes are not to be the party of the illegal mining of Kazunga National Park. That is going to. In our Cardialam specific order has been passed by the Cardialam of the first council, and we have filed the activity, including the petitioner. In those cases, it is not within the purview of the Supreme Court. No,
don't crush it, they can take back, you mean.
no, my lord. In our, my lord, in the Cardialam area, there is specific direction not to transport the illegal mining. And the petitioner's school cluster has been declared as illegal mining stoppage of that particular unit, my lord. Those mines which are lying, these are the my lord, illegal mining. It can be confiscated by the authority, my lord. So they have to approach whether they want to take out the materials.
No, you see, the stone crushers are used for mining. They are not mining. They are only mining equipment. They can take out the stone crusher. They cannot,
Material.
the materials they cannot take out.
Material.
Stone
Yes,
crusher they can
yes,
take it out.
my lord, stone crusher they can take.
Stone crusher they can take.
Not check clearly. Stone crushers they may take it.
Stone crusher you can take.
Yes, sir.
That is only mining equipment.
Only the material part.
Materials,
No, materials. No. You see, materials for the simple reason, there is one thing. You filed a writ petition in 2019. In 2025, after 6 years, you have come to this court by way of an additional affidavit, saying that I had already minded 6 years back, let me take it out now. So that you had bought it,
Okay,
bought it, correct?
That it shows to be a statement.
Then what?
Yes, yes. You know.
Where?
Yes. Followed at page 29. At the time itself, followed the
Maybe, but if you go to the committee, I will not.
the bills are
Material is not. But with regard to stone crusher, you can take it up.
well. So we can place go.
And what about the next page?
The same one.
So can be disposed of. Okay, right. Heard Mr. T.S. Sayawala, from the Senior Counsel for the petitioner, assisted by Mr. H.K. Khan. Also heard Mr. A. Sutil, then Standing Counsel, K. The petitioner had initially prayed for the direction to be issued to the respondent to forbear from giving effect to the action of the respondent authority in directing the petitioner to close the crusher unit, stone crusher unit of the petitioner located at Tarso Terang Down, Dola Mora, in the district of Karbi Anglong, and to renew the stone factor license of the petition for operating the field. It's both, in both same area, a petitioner, not petitioner. However, the prayer of the petitioners has now changed with time. The prayer of the petitioners, as of today, is that they should be allowed to take away the stone crusher unit from the place where it has been uh, stationed, and also to take away the materials that had been, the stone materials that had been extracted prior to the issuance of the order of the Honorable Supreme Court in the case of T.N. Godavarman, Hiru Mulpat, bracket 50 versus Union of India and others, reported in 2013, 8 SCC 198. Sorry, in T.N. Godavarman, Timurpad versus Union of India and others, writ petition civil number 202 of 1990. Yes. 202 of 1990. Next part. In T.N. Godavarman, Kerala, Mulpat versus Union of India and others, WPC 202 of 1990. The Supreme Court had. Where is that order? Page 28, my lord, also 50 to page 27. Eight to the main. Second. Page 20. And the Supreme Court has directed the Director General of Police, Assam, and the concerned Superintendent of Police to ensure that no illegal mining took place in the Kaziranga National Park area and in the entire catchment area of rivers, streams, and rivulets originating in Karbi Anglong hill ranges and flowing into Kaziranga National Park, including Tiger Reserve. So what the messages we contact? You know, that part of the Director General of the Director. No illegal mining, no illegal mining and transportation of illegally mined material took place. By order dated 12/4/2019. 12/4/2009. Next one is page 20. Page 22. Well, next one. The petitioners counsel submit that the mine stone had been. Where is that letter you showed me? With regard to the mine page, it's that stone. Page, follow the page, follow the 29. So the mine stored material had been mined prior to the ban on mining related activity by the Honorable Supreme Court of India.
And we are only paid.
And as royalty has been paid for the same, the petitioner should be allowed to remove the same from the area where it is stored. Next, the gate between United Council is, on the other hand, submit that in terms of the order dated 9/5/2002 issued by the Honorable Supreme Court in the case of T.N. Badavarman Perumal Part, bracket 50 versus Union of India, another 2013, 8 SCC 198. This is what order. This cannot be 9th May 2000. And the Supreme Court has held in para 1.4 that any individual having any grievance against any step taken by the government or any other authority in compliance with the orders passed by the Supreme Court would be at liberty to move the Central Empowered Committee for seeking suitable relief. The committee to dispose of such application in conformity with the orders passed by the Honorable Supreme Court or refer it to the Supreme Court. He also submits that an affidavit has been filed by the KAC on 5/11/2024 in the Supreme Court where it has been stated that all mining activities inside Karbianglong district bordering the southern part of Kaziranga National Park has already been closed pursuant to the meeting of the Central Empowered Committee. Further, notice to close 33 stone quarries and 18 number of stone quarries as well as 18 stone stacking units had also been used. It submits that the same, then it submits that the said, the above stand of the KAC has been recorded in the order dated, when the order dated. The order dated kind of case by the second case by the 2011-2020. 2011-2024. 24. Last is the T.N. Bavarda Park, Tirupal Park, was the Union of India. This petition, civil number,
No order for lifting the closure of the quarry.
the 2002 tax title.
Last page, but no new order for lifting the closure of the quarry.
Last page is not there.
Like 18 page number 18. First line, other. No new order.
Just report that. It has also been stated in the affidavit that as per a letter dated 7/5/2024 issued by the Divisional Forest Officer of KAAC. No new order for lifting of the closure of the quarry has been issued. Has been issued. Next one. The 11th Council for the KAAC has also submitted a letter dated 35/2025 issued by the Central Empowered Committee, which is, which it to the effect that
Is in paragraph nine.
which to the effect, which is to the, which is as follows, no? We just take the para nine. Wait. I have heard the learned topic. As now, on a perusal of the various orders passed by the Supreme Court and the Central Empowered Committee, it is clear that the it's clear that no illegal mining, no mining activity, no mining, no mining of any kind or its related activity can be done along the Kaziranga National Park area and in the entire catchment area of rivers, streams, and rivulets originating in Karbi Anglong Hill Range and flowing into Kaziranga National Park, including Tiger River. As such, the prayer of the petitioner to allow him to transport the alleged mine stone mineral cannot be allowed by this court. The petitioner would have to approach the concerned Central Empowered Committee with the above prayer for transportation of the stone mineral or stone mineral outside the Kaziranga National Park. It would be in consonance with the order passed in P.N. Godarbaman Perumal Park, bracket 50 versus Union of India, another 2038 SC 19. Para 1.4 of Para 1.4 of right. With regard to the prayer of the petitioner to allow them to take away their stone crusher unit. This court is of the view that the stone crusher unit is not a mineral and is only an equipment used for mining purpose.
No mining, for crushing,
For crushing,
crushing or
for crushing, for crushing, for crushing the mine mineral. In that is the matter. Court is of the view that the prayer of the petitioner should be allowed. Accordingly, the petitioner is allowed to take away his stone crusher unit from the Dolamura area of without any permission being without the stones that have already been cut by them. The repressions accordingly are accordingly disposed. Oh, so who is not must have forgotten. We'll wait. More. Yes,
We have already started the not very. For Commission on Dedicated Bills and Housing.
Let's talk about funds. What are you validating? Why are you going back in time? That is not the issue.
If submit the certificate, then we submit the certificate.
So we'll have to do what to do.
The 19 now when it's a big fight. They are required for the different. I was there to get time.
You see, this is all time wasting tactics. That's all. This, you see, in 2022, the proposal for payment of pending liabilities has been made. Now you're asking for validated vouchers. What is it? What were you doing then?
One letter from the certificate from PNRD from Governmental Staff. There is some queries and the certificate for senior most certificate department to be submitted regarding certificate of sale. Then
Page? Where?
instructions. Instructions additional. That is 24 September 2020. Instruction page number 3.
Yes, who is for the district commissioner, Gauri? Yes. What is your stand? Where? What have you said?
Yes, we are getting funds from the PNRD department. In the year 2022 as well as year 2024, we have got funds. For the PNRD department. So please look in the field, page, internal page 60, as you are.
Yes.
It is addressed to Commissioner PNRD by the Deputy Commissioner. Yes, for additional funds.
Now they are asking for validated bills vouchers in origin. Have you got this letter?
Not ever.
Yeah, you write this letter after 1 year. When? That is last month. This letter of DC is of 24, March 24,
22 also.
22 also. What is this? Now what is to be done?
In 25 also we have to, for the PNRD. Yes.
They divided by the become now when the big petitions and the private petitions.
I think the commissioner has to come here to this court. And then when were the supplies made? When? Whatever. So when was it? When was it done? Bills have been pending for how long? What?
NRD is the concerned department law. The blood work that was done for the technical funds were required, but they had approached the finance department. But now they are trying to streamline, but they are having several cases which your law was also seen blood. So they have proposed, they have made a consolidated proposal as regard the outstanding bills of our year panchayat elections blood. So this, they have taken up this proposal. And in that same process, Lord, for this work also they have written. Because until and unless Lord, the utilization bills and all are not furnished, Lord, the finance doesn't release. And in some of the cases, your lottery was even pleased to make finance a party. So that is the difficulty, Lord.
The problem is you are delaying the matter.
Lord, to give one opportunity, Lord, things are being streamlined, Lord. Earlier it was not in the time of take it to your order. Because
Yeah. And luckily for you, that stage has not arrived. They're not doing anything.
they are yet to get not the not the lordship gives an opportunity, Lord, perhaps not time, Lord, they would be in a better position.
When can you submit these validated bills and vouchers?
I'll definitely inform them.
Okay, right. What is your name? Ms. N. Bora, appearing for the PNRD department, has submitted a letter dated 2/6/25 issued by the Commissioner PNRD SM to the District Commissioner Nalbari, requesting him to furnish all bills / vouchers bracket in original, utilization certificates along with other relevant documents certified by the concerned authority pertaining to the requirement for rupees 2,21,80,590. That's correct. The Mr. G. Bokalian, appearing for the District Commissioner of Barichat on the next date, informed this court as to what steps the District Commissioner Nalbari has taken with regard to the letter dated 2/6/25 issued by the Commissioner PNRD. The letter dated 2/6/25 issued by the Commissioner PNRD is made a part of the record and marked as an exhibit. This is the matter on. Give a date. Meeting. Yeah. Now, what I've noticed here is that that earlier judgment passed by the by court number 5, I think. Now, out there, Ministry of Jal Shakti and Brahmaputra board were already there.
No, the even and got the money.
They've got the money. I know, in this series they have been implemented. So in that bunch series also it was already implemented. So what different order can be passed? Only thing I want to know is it 80%, 80-20 or 70-30 or 90-10? What is the? What's that order? Give me that. The one you took. No, that order I got, one order, but then with that slip. Okay, now what was the total cost estimate?
And from here on, every financial year.
What do you mean? How can there be a different estimate, different cost estimate?
What I mean to say, in every financial year, the central government if, um, you take equal, so, you release the fund on equal, 80-20 more.
How much has it released?
But we have to make the
Show me.
total estimate of was 341.45 crores.
Where are you getting that amount?
March pay last time. March, that later look, that we can put it. Secretary, Ministry of Government of India. That letter is been issued by the people secretary.
Yeah,
That letter dated 5 March 2020.
yeah, yeah.
Last time of it.
yeah.
And the state, the total estimated cost of this scheme was rupees 341.45 crores.
Have you given a copy of this letter to them? No.
Well,
You are for whom?
I am for the water resource department.
You are for the water source.
I have shared the same with my colleagues.
Mr. Council, you are reading whatever part you like. Please read the third paragraph. Fourth paragraph.
Yes,
What? Please read.
the correct thing.
Based on the approval.
Based on the approval of the planning commission for these so administrative approval was recorded by government of Assam by letter so for an amount of so when the IMC approved this so on
a total of demand has, 20 rupees has already been released as central share, with an additional rupees demand as a share. However, rupees demand, 20 lakh has been disbursed above this amount by the state government against court case to contractor.
Now you please decipher this. What does it mean? What does this letter mean? What does it say, basically?
Basically, it says that a central government has released a portion of the fund.
How much has it released?
Central government has released, approval was recorded, 110.60.
Yes. Yeah, if it's 5
You're not getting it at all. It is a total of 2503.
Total of 2503 has been released as central
With an additional,
for additional rupees 1297.244 that as state share.
yes, but now will 1297.244 be 20% of 2503? It is half.
Yes.
What figures is this? What figures is your special secretary, chief secretary giving?
So let me clarify this.
Where is he? Is he here?
But if you talk about data, I guess the data was one.
You are saying that the 90-10% has now been changed to 80-20. So if 2503, 2500 is the central share, 1300 will be what? 20%? More than 50%?
More than 20%.
More than 50.
Yes.
So where's the question of if state share is 1297?
No, that release with an additional rupee demand as state share.
Correct. State share means what? State share means central share or what?
No,
Then if state share, I make it very simple for you. Forget or just make it say 2503, make it 2500. And 1297, you can say it is 1300. Is 1300 20% of 2500?
more than.
More than 50%. So where is the figure? How is the figure not telling? What is this?
Let me have the clarification on it.
Yeah, don't try to confuse the court with figures. Because we are succeeding in confusing the court. We want it simplified. I do not know what kind of a mathematician he is or a magician, but this does not come to 20%. Yes, Ms. Patan, you are spending your time.
File by the item number 38.
38, give it 38, item 38.
That affidavit was served on all of us because that was the cover of the. So. See 187. After affidavit was filed on
Affidavit of response number 2.
5.
Yes, yes.
Copy may have page number 33 of the affidavit.
33.
That's 33 in the copy, sir. Paragraph number 6.
Regarding these case, declares of people like.
33, para 6.
Paragraph
Yes,
at the bottom of the page. So, in response to the statement of item number 12, that couldn't get the following code number 2. Next page, cost as per IMC, which is 38.95 lakh.
What is IMC?
That has not been clarified here. Then central share is 5.
You're sitting down, we're asking you and you're pointing to your colleague.
Yeah, this is the affidavit filed by the central.
Okay. Who is the responsible? Who is the, this is five, the 5 and 6. Five is Government of India, 6 is Brahmaputra Board.
Children savings. They want it to personal.
I can't mention it. Yes,
So from this affidavit amount, here the amount of fees, 1159 lakh. 1109 lakh has been disallowed from CAQ. This is what it appears because
disallowed meaning what?
I do not know, because then they go on to say that if the government, water resources department of the government of Assam provides the necessary clarification, that will also be fine. At page number, paragraph number 8, page number 35.
Yes,
They said in replying to the statement that paragraph number so and so the concerned department of the government of Assam will submit the funding proposal in all respects of the above project. So all eligible documents will consulted with the state government without further. Now in the, if in my matter, the government of Assam has already agreed to work. On this affidavit, it appears that some of the thereby due to which the central government has not been. And they are saying that if the government of Assam needs to the victim, submits a funding proposal, complete all those expected funds.
anyway, so as per this page 40, page whatever, para 6,
Yes.
the cost as per IMC is 3895. Central share release is 2503.
Yes.
Less amount disallowed. Yes. Now, how much is the state share given? I don't know. Nothing is clarified.
But the stand taken by, I mean, till now the stand of the Dr. Assam also is the central funds are released to them, then the use of the campaign. So perhaps this has to be clarified that if the, by the central government, if the corrected proposal is sent by the government of Assam, then perhaps
Yes, we for the central state government.
what is the
No, no, state government. Who will know the amount that has been released by the state government? Any affidavit? The state share, how much state share has been released? No. State share will be by the finance department. From water resource department, from where will they get the money? All the money is given through the finance department.
I can have it tomorrow because uh, the is available to guidance. I need to see the instruction which I learned better also provided because state government right now.
Who is the guardian of state finances in the state of Assam? That is who? PWD, water resource. Then you are supposed to know all this.
That's it. Regarding that, I can check you. Allotted that you might consider.
Allotment is not the issue. Allotment is not your concern. Your concern is with regard to release of a certain amount of money.
Yeah.
Now, how much have you released? For how many schemes are there? 2 schemes. How many schemes? How many? What is the name of the scheme for?
The name of the scheme is
Or what is the head under which the money is supposed to come from the finance department? There must be a particular head.
yes,
It cannot be 2, 3 heads. It must be one head.
the applicability is that quoting layers one place. Might be given. Paragraph number 4.
Scheme code AS 103. No, this is only with the scheme title RS to T Dai Color Back Populi from Chairagi to Klaituk. Are all your schemes with regard to this RS to T dike along with both banks of Kopili River from Chairagi? All of you, all the petitioners? No. Different day. That is what, no. So it will be that it doesn't come there. Yes. Or does it come under the scheme code of AS 103? I don't.
Setting up 1/8/22. Okay.
Yes, I can take it up.
Page 13, that's the,
Page 13.
definitely different process, but
No, that is the name of the scheme. I want to know the head.
the name of the scheme is long, that's what I said.
No. Because, because your scheme name will be different. Ah, what is the name of the scheme?
It's flood management in border areas.
So this is different. This one is different. This item number 38 is different. This is a different scheme. But I want to know the head under which, yes, the head under which the money comes from the finance department.
That that is created by the water.
Correct. But then you're giving money to different heads or one head. Then you have to have that head. Water resource will use a head, but you have to give it to that head.
What is the, I'll clarify also. Because how it is.
No, you see, the issue is not a management, I think. That is not your concern also. Your concern should be, what is the matching share given by the scheme for the said scheme? Now, yes, the amount, that the exact amount of money given. And so that amount and how much did the central government give? Because the central government will give it to you. To you.
Clarify.
No, to you. That dismiss thing has started only just a year back or 2 years back. Earlier, everything comes to the finance department. Now it goes to the various authorities to IFMIS. So that's a different method of accounting now. Mr. Gogoi, anything to add? We'd like to have the correct. No. Earlier that was the thing. Now different. Only thing is that this is now we want to know is what is the amount that has come. Now you come to this you see this affidavit. Problem is, madam, for Ms. Gayan, item 38, you have filed an affidavit, item 38. And at para 6, you have said cost as per IMC. Now, what is this IMC? First of all, cost as per IMC is 3895 lakhs. That means 38 crores, 39 crores. There. Central share is already released 2503. Less amount disallowed 11596. Now, what do you mean to say? Do you mean to say that out of the 25 crores that has been released, 11.5 is not being allowed to be released by the Accountant General's office or what? So the Accountant General also will have to take a call on this. What does it mean? And then if that be the case, if 2503 has been released, what about the balance 3895 minus 32503? That amounts to nearly 14 lakh, 14 crores. Why is that not really? We'll list it next week. We'll take it back. Because unless we get to the bottom of this, nothing's going to happen.
When the CAC, they used to have a report, they used to make certain observations. And the concerned department will have to kind of look up those observations or incidents. We'll have to see what was the step taken for meeting of those things. In that case, they will allow meeting of that.
No, that is one thing. And we have got to understand this. What does it mean? Cost as per IMC. Now, what is IMC? First of all, we have got no idea. Is this 3895 the entire cost of the scheme? If it is the entire cost of the scheme, then the 10% payable by the state would have to be 3 crores something, 4 crores, nearly 4 crores. And then what about the balance between this IMC rate and this central share release? Another 14 crores. Integrated? No. So it appears that the entire scheme is for 3895. That is 39 crores. If it's for 39 crores, so why has central government released only 25 crores? 14 crores still have to be released. Then less amount disallowed by CAG. Why? Audit 1159.76. Why? So does it mean that out of the 25 crores that has been released by the center, is 1159 has been kept by you, not to be used by anybody, or has it been diverted somewhere else? This item 38. No, but please, please try to get instructions on para 6. Because they have said less amount disallowed. Disallowed means not allowed to be paid. It appears maybe. Now, if you have not allowed payment of 11,459, where is that money? If it is not paid, where is the money? Now, how much has been paid out fully? That also is an issue to be taken. Out of this 25, this is only the central share. What about the state share? How much is state paid? Who is for the water resource? You. Now, how much have you paid out? How much cross have you paid? Which class? Where have you paid? Where? How much has been disbursed by you? Who is the paying authority? Is it the water resource department who pays the amount? What is so please tell us how much have you paid? How much money have you given out? If it is 1297 for two, so 1297 means 13 crores. If you have paid 13 crores, then there is another 12 crores in the bank. Because center has released 25 crores. So why haven't you paid the rest? And why are you shouting that there's no money? Central share
whichever we have received is already been paid.
Because that is the issue. Now, either you are saying that uh, this affidavit filed by the government of India is a false affidavit. That's what you're basically saying. Because you are saying that there's no money. But then they are saying that they have given 25 crores. And you said that you have paid out 13 crores.
No, 30 crores of the state.
When he paid that, when central, Mr. Counsel, please try to understand. What do you understand? You understand this for the simple reason that 80% has to be paid by the center, 20% by the state. If the central government has paid 25 crores, how much is 20% of 25 crores? How much? 5 crores. If it is 5 crores, yes, so 25 plus 5 will be how much? 30 crores. And according to you, you have paid 12.97 crores. That is say 13 crores. So where is the 17 crores? That is why you have to, you've got to give the exact figures. What is going on? Is there something that we don't know that is going on? Or something that none of you all know? Yes. What is to be done? Clarification has to be done. How much has been? No one knows anything. He doesn't know. He says that uh, the 12 crores is the state share. When the central government is giving 25 crores, how you are supposed to give only 5 crores, no, not 12 crores. No one is going to give you more than you ask, especially money. Right. The affidavit of the Commissioner Government of India. Government of India? Commission?
File where it's 20 years now.
What is this? How can a superintendent engineer,
Another aspect of it.
how can a superintendent engineer file for the government of India? Superintendent engineer of Brahmaputra board? What authority has it? How can he file? I think the superintendent engineer has to appear before this court. How can he file? Has he been given some authorization letter by the secretary, Raj Shakti board, Raj Shakti ministry? Huh? What is this? Brahmaputra board, who represents the Brahmaputra board? Who is the head of the Brahmaputra board? Huh? Chief engineer. Why is the chief engineer not filed any affidavit? Right. The affidavit filed in favor of the Union of India, represented by the Commissioner, Ministry of Raj Shakti, and not and the Brahmaputra board, represented by chairman, has been done by the superintending engineer of Brahmaputra board. wherein it states at para 6. As follows, huh? This para 6. This blue portion. Next one. The details of the scheme, next para, the details of the scheme as provided above. Prima facie shows that the cost of the scheme is 3895 lakh. And only rupees 2503 lakhs have been issued by the center. This aspect will have to be clarified by the central government as to why, by the CGT, by CGT as to why the entire 3895 lakhs has not been released by the center. The details of the scheme provided in para 6 also shows that an amount of rupees 1159.76 lakh has been disallowed as per the CAG bracket audit amount one. The so we make this a separate paragraph. Huh? The counsel for the CAG audit what it can obtain instruction as to the reason why rupees 1159.76 lakhs has been disallowed. It can also obtain instruction as to the amount of bills allowed in pursuant to the said scheme by the CAG audit one. Next paragraph. The Mr. R.N. Das, Direct Counsel for the Water Resource Department, shall submit, shall obtain instructions with regard to the exact amount of state share provided by the state government for the scheme. Inasmuch as the letter dated 5/3/2025 issued by the Special Chief Secretary of Staff does not give a clear picture as to the amount of state share released by released. That's it. Next paragraph. Mr. A. Chaliha, the learned counsel for the Finance Department, can obtain instructions as to the exact amount of central share released by the center and the state share that has been provided. The, the original funding pattern of the scheme was initially 90% central share with 10% state share. The same was revised to 80% central share and 20% state share from March 2015. Thus, it is imperative that the finance department give a categorical and specific number with regard to the exact amount of state share released till date for the said scheme by the state of Assam. Anything else? This is the matter on Monday. Why 11? Okay, 11. Huh? Okay. Hmm. Is the matter on huh? Hearing day better. 12, 11, 10. 11. 10, 10.
Yeah.
Fine. Your friends can come. You don't need to come. You'll keep on changing anyway.
No.
Okay, 11. It's the matter. As partners. Huh? Let them give mention memo, all of them. We give mention memo, don't worry. Yes.
Yes, for the complainant, if you put the public of the area where it's supposed to execute the work, they are not employing over there. Those some time. It's after 70. Regarding it past, the big people of work, there comes up to.
Oh. Okay, right. Heard, mister? AMS Magundala, Office for the Petitioner, submit that the petitioner has been given letter of acceptance. Dated, dated, I didn't ask you the page. Huh? 7/3/2025. In respect of NIT dated 5/9/2020. However, no work order has been issued to the petitioner. Mr. B will submit a appeal for a week's time to appeal inspection. This is a matter of when that is
The wife of that.
I don't get for any contact with my clients.
so we'll dispose it off. They don't want to give you your fees, I think. Yeah, look, if you don't have any contact with your client, now what can we do? That is your problem. And we have given you time of huh? Correct.
I have also received the same.
So we will all look at it together. Let us see. You've gone through it. Then end of the matter.
Because wife.
Your claim for money. Yes, what?
It is right. It is right. I don't have whatever. Why does he want to come on the political?
I know 27 lakhs. Yeah. Okay, right. Heard Mr. A.R. Tabindar, that is passed for the petition. Also heard Mr.
Yes.
Huh? With K data, then also for the response. Okay. Agreed by the non-payment of contractual fees. The petitioner has filed the present petition. Mr. A.K. Data, then is passed for the response. Submit that the present writ petition has become instructive as the subject matter in issue has been decided by an arbitrator by award dated 10/9/2024, wherein the petitioner's wife has been awarded rupees 27,08,431, which is to be paid within 90 days, failing which interest is to be paid on the same. Mr. A.K. Data also started that the writ petitioner had died during the pendency of the writ petition and had been replaced by his wife during the arbitration proceeding. The award dated 10/9/2024 and the letter dated 22/11/2024 issued by the Government of India, Ministry of Communications, Department of Posts, Office of the Chief Engineer Dash, Roman 2 are made a part of the record and marked as an X collectively. In view of the content of Annexure X, the writ petition is closed as improper.
I don't know. Have taken steps also. It's already filed the one.
So what is the, so electricity was not supposed to be restored. Then what is your complaint? What is your problem?
Kindly matter come up along with the policy number 62. And then which matter.
No, Mr. Counsel, why have you filed this contempt?
Dependency of the order dated, then directed.
Not to give connection.
Matter come up along with WPC number 4708 of the 21.
No, tell me, so has electricity been, electricity connection been given to the respondent or to the petitioner?
Yeah, electric connection has not been given, but honorable court order dated
Page 23.
17/9/21. They have verification report. They have been filed prior to honorable court. Prior to honorable court's order, 16/9/2021.
So, if it is prior to court order, then
No,
there's
it's
no
prior to
contempt.
court. Can be possible, Lordship. Prior to court's order, court order is 17/9/2021. They have verified, Lordship, 16/9/2020. As per their documents, that's why I'm praying for
Okay, right.
this matter come along with that payment. After the order, after verification, that your detailed report was prepared, that is the report. It may be, Lordship. The position is that court orders such as no question.
Correct. No,
Within the XYZ fast track, only 383 domestic. That we understood the really connected. So that domestic connection to what is the because there is still no proper demarcation, it is not, we do not know which area is there. But after the order of the court, no connection. That is the order which they are already carried. Contained will not have. In the content,
when is the report?
that your lordship will find a page number 57. Seven of our application.
Yes.
If we kindly have paragraph number 4, yes, after the court's order, 29/1/2023, the random joint inspection was again carried out by a team from so and revealed that one representative of so was present at the site. As per the survey made on 29/1/2023, the license of Dr. So and so could not be identified as separate, as the entire area is having a single access point and one to one. Also, construction work was going on in the building, which was to be carried out by Dr. So. As on date, also the premises are not executed, construction work is going on in the entire. During our visit, representatives of so claimed that the entire premise has been developed by network so based on the numbers of specific identifiers and land development container and facility. Representative of so also furnished the copy of presence of the EPN and how it is tailored. It is to be noted, it's the copy. But there is one commercial connection to device standing in the name of developer for so and so, with consumer number so and so, and it is running from 1/1/2015. It is to be mentioned that due to construction demolition of the important device surrounded by the same boundary wall, is now not feasible on our part to identify the premises of separate and honorable court intervention is required in identifying the scene. Identification of the premises of separate can be done by the complainant with the help of the honorable court and departmental officer. Physical description of the separate plots as claimed by Mr. So can be. Now, Lordship may have been ordered with the alleging violation of that the operation part is the page number 55. It starts at the bottom of the page. On the returnable date, that is so and so, the respondent institution shall apply to court about the status of connecting the house with the principal, and also about the email dated 39. In the interim, the respondents shall neither destroy electricity connecting the house with the above, nor shall provide new electricity connecting to those electricity to the business without leave of them. We have not done that. Highlighting respondents in the application highlighting one of the relatives, not against the High Court order. On dated on 29/1/2000 only only this date may be mentioned.
What are you trying to say?
But if I be allowed to this matter may come up allow me to.
Why?
President already let's this pending.
It's a concept. First time petition. Can only be pursued if there has been violation of the court order. And is it violated?
One kind of and both here passing by the next one is basically
Mr. Counsel, the long and short of the question of my question, has there been a violation of the court order? That's all. You have got, and you have got nothing to do in this matter. It is between the respondent and the court. You got no say. Fix as a, between the, it could be heard. You cannot use it as a, use it as a pressure tactic. Right, what is your name? Right, Mr. Please go ahead. For the petition. Also heard Mr. KP Pathak for phone number is 1. What have you got to say? You got nothing to say. Okay, Pathak for the phone number 1. The present this petition has been filed. The present petition has been filed by the respondent on the ground that the order dated 17/9/2021 passed with WPC number 4708 of 2020 has not been complied with. Come on, where is it? It has been stated. Where is it? Has been directed, that's all. Page 55, submitted. The respondent number. Respondent number 1 to 4 have stated their affidavits that on 29/1/2020, another random joint inspection was carried out by a team from the Chief General Manager, AT&M, Bijuli Bhavan. During such inspection, one representative of Siemens Telecom Builders, which was was present at the time. During the survey, the position of the certificate, Dr. Prasanjit Thakur and heavy builders could not be distinctly identified as separate spots, as the entire area has been access and as well as boundaries. It was communicated by the subdivision of the capital subdivision to the chief executive officer. What is the perspective? So basically, we are not sure whether it is the connection is with Helicon or it is with the predicate. Yeah. Both of them are taking that. One of the other parts what's to be done? We have not done that. Now, depending upon the outcome, perhaps as such, until and unless it is clarified by the revenue department, by the revenue authority, or this court has to the ownership of the said property, wherein CLC commercial category electricity connection having a connected load of 14 kV is clarified. It cannot be said that there is any violation of the order dated 17/9/2021, passed in WPC 408 of 22. This is that is divided for the letter dated 31/5/2023 issued by the subdivision legislature to the chief executive officer, Party Electrical Circular. On perusing the letter dated 31/5/2023 and keeping in view the contents of the affidavit filed by the respondents number 150. It cannot be said that the LP commercial category electricity connected having a connected load of 14 kilowatts in the name of Subrata Corp of MS Helicon Builders has been amount restoration of electricity connection in the house of the petitioner. House of petitioners. They are petitioners, obviously. It's a question of fact. That's that. This court does not find any. This court does not allow that the first petition should be closed at this. After proceeding accordingly. I think that we start from the note 7. Page 71. Particular paragraph number. No, you see, paragraph number 2. The amount that we, the amount which is total amount is page 50, 70. But what is the fourth schedule to do? What is the fourth direction? Is number 32 says that on verification can install it. That means the are found to be correct. They will and they will then the thing is so when are you paying? Every financial year we get that on that. When we allot to the all the part of the payment, then 10% will be releasing 25, 26. After that, if you all the amount has been accepted, all the amount has been used up, for private purposes or for all development work and all the we tender when we are meeting things for different purposes. When you give someone a work order or a contract, do you give it without any money being in the bank? No, so Mr. Council, my question is, do you give work orders to persons without there being any money? When did he complete his work? Order is long back. When? Huh? He finished his work in January 21 and you have not paid him money. There's 10 crore. 10 crore something is still owing. That's the picture. And you are admitting that you're owing. So you give work without any money. You finish, they tell them to finish work. and then you tell them you wait for 20 years, then I'll give you your money. What kind of a office, what kind of a authority are you? You're what? You're what? You're BTC, you're BTC. BTC. So financial power you don't have. So who gives the work order? BTC gives the work order without having any financial power.
Now we are getting it.
So you give work orders without there being any money in the bank. Huh?
That's a topic. What about this?
Correct. But from the so before so when from the Assam government, when the money comes to the BTC, you all don't take out the money and say this will be for this contractor. You all don't say that. Huh?
But the department was looking for that after the.
Department wise allotment. And then when the department and this department is which department that gave him the work order? Forest. Now, when Forest gave him the work order, the Forest Department did not have the money for that contract work, correct? Huh? It did not have any money for the contract work. Just give it like that. Huh?
Fine, system is that build earlier system these things can happen. So thereafter, my lord, how the new dispensation and then employee was all this more for them. Immediately, the retail is just all the 3,000 crores.
So have you caught those persons? Have you taken any action against those persons who did some illegal work? Because you are saying what you're implying is those persons did some illegal thing. Correct? Illegal. If it was illegal, why haven't you taken action against them?
I thought that the ultimately came out that some internet, just half of the percent of the work are fake, they're all.
So what action have you taken against those persons, against those officers,
That is the
against the contractor?
that is the
See, you say anything that comes to your mind in the court without any backing document. And without you taking any action.
that has come up on that amount is due. And you're planning to release it.
When did you pay this amount? It's very easy to say that he will be paid in the financial year 2025, 26. When? 26 will end in March 27 or 26. When will you pay? And that also only 10%.
That we make
When?
immediately that funds come from there to release it, but that
When will the funds come?
funds after March, my lord, generally comes around in July. There is no fixed date. Usually funds,
Right, right.
they have taken the which made 5 people
Huh?
as per the deputy with lordship. And about the deputy with lordship. As per guidelines issued by the voluntary department. Council 5 memo number 7 dated 5/8/2023. It is stated it is agreed in principle that a target of maximum 20% of the total associated fund may be kept for financial care for the to article liability to 2008 to 2020. So, at the hospital also, they have to dedicate full amount. Regarding my they have making some development, they have not followed that. They have these in the month of May also they have billing process. Some of my information lordship, they are trying.
This is in direct violation of the court order. You know that the court order has not given direct. Court order has not given the. Okay, right, anyway, right. Third, Mr. S. Bora, now talk about the BTC will submit that as per the affidavit dated 28/5/2025, issued by the submitted by, that is point number two. The petitioner is to be paid rupees 10,96,14,440. And and that 10% of the same will be paid during the financial year 2025 tax benefit. This is the matter. It's the first week of July. Oh, then first, this is the matter on 26th June.
What's the one sentence, brother? About that. Pay loss of this. After deduction of income tax and the debt load, that will be, the amount is after deduction of that effect.
Okay, that 10 lakh, that 10 is after deduction of income tax,
CGST,
PGST,
FGS.
and GST. Huh? Don't forget to put it.
Yes, I have to stay for 9/12/2020.
No ID card.
Which was the latest one.
Huh?
Now, the company has divided this open.
That,
They belong to.
okay, Mr. Boro, let's talk about, huh?
Airport.
Boro. Let's talk about the petition, submit that you'd like to file an application for reading the new income. This is the matter of two.
It is 77.
Huh? 77, 78, both. Yes.
Hi.
Okay, please, Abhi Bora appearing for the respondent.
Hold it.
Submit that. Your file affidavit within. I want the affidavit when? In the date of the thing. No, 78 on. Just yes.
The committee is prosecuted by the government. That committee has examined case of the other and after consideration by the it has been approved. Yeah, on examination of their including other approved. Now the director has is the method for the concern of the monitoring that the committee.
Here is my copy. So you be given 7 lakh.
There are bills which I have submitted. All of the bills are in it. There has been a receiving also around something around 15 lakh. Here, we get no records are available. There is no transparency required. That has been accepted in 2014 itself. So Lordship may see at page 19.
Why can't you give us a better copy?
I don't.
Why don't you give us a good copy of the audit? What is this? You're a state government giving such bad copy.
There, 22, kind of, like,
Whatever it is.
according to the committee, total in cases 7 lakhs, the genuine bill on examination.
For all three cases.
I don't.
For all three cases.
Yes,
For him, how much?
What the name is not,
I'm not on their claim. How much have they admitted?
they have admitted 7 lakhs 46.
7 lakhs, about 2 cases.
No, that's for two cases, not for you.
Yes,
For you is different.
yes, my lord, that is. They have total, my lord, in 2 cases, 7 lakhs 46,257 point.
That is for both, that is for you.
That is for me. In two cases, two
Up-
cases,
up-
it's like two bills, but they were two bills, pending bill. Then one bill which they are saying that they don't have record, so they are not paying it. I just saw the report. And that bill has been accepted, they have received that bill. They are saying that no record that is available, so I'm not paying. That bill has been, but has been accepted by the 2014.
Yeah, for them.
My lord. Here is an exception, admission in this part also, my lord, may come to his reply.
There is no admission.
At-
In that case, my lord, lordship, maybe please to hear the matter. Right there. If that is so.
My lord, please come to my lord, page 71 of the reply.
Yes.
Look at the last paragraph. Out of, if I may, out of the balance amount of 8,47,890, as mentioned above, the two firms, Messrs. Ajita Chaudhary, which is me, and Messrs. Bala Bamuni Madam, claim rupees 23 lakh 12,109 against a pending bill. That's on the next paragraph. On a fifth line, on successful completion of the work, the firm submitted their bill, moreover, a tender for limitation on cover of the guard under NFA so and work order basis method Ajita Chaudhary not party as per the lowest rate of rupees 0.75 per copy offered by the firm against the tender. On successful completion of the said work, the firm submitted their bill. Even details against the bill submitted by them is also enclosed here. This bill is included as well.
No, it does not say three. Where does it say three bills? Talk about only bill.
Well, bill, so that three bill combined is 23 lakh.
Mr. Kaushal, that this they say on verification that you're not entitled to it. Okay, this,
Not entirely because they don't have the record.
then you go in the bid for, you go in the field to,
That aspect needs to be decided in the rate for three. Yeah, so subject to submission of the bill because they said that they don't have the bill.
Put directed to verify the bills.
as per Sanjay Rally, see, a report is only for, where the facts are not disputed. And where facts are disputed, then we, out of understanding for you all, we direct that a verification to be and the admitted amount is paid. The non-admitted amount, you have got to go on your own way. You've got to, there is evidence required.
There is respect for private internet facility. They were only asking for a resubmission of the bill.
Let us see what the report says. Let us see.
Whether it's for the Page 24.
Yes,
With the operating part, I mean,
yes,
para 6.
yes,
Para 5.
yes.
Taking into account the above stated, court therefore is of the opinion that the interest of justice will be met if the petitioner is permitted to submit his uncleared bill in the proper form. And the direction is given to the concerned respondent authority to make payment to the petitioner the amount which is entitled to necessary verification. Whereas, accordingly, the court therefore disposes of this instant rate petition thereby giving the liberty to the petitioner to submit his unpaid bill in the proper form. And thereupon the respondent 5 and 6 shall make necessary verification as regards the petitioner's entitlement. And upon verification, it is found that the petitioner is entitled to the amount so claimed.
Upon verification, it is the first.
But upon verification, when I submitted the bill,
There's no point.
my verification is also over.
No, no, no. You can always do the second 14. Limitation Act.
That is what is applied, the contract state.
You see, Mr. Counsel, your mistake has got nothing to do with this. Sir. Your mistake is not going, your mistake's not going to a civil court earlier.
And let us kindly come to page 19.
Heard, Mr.
Page 19 states that acceptance measure of the excess sufficient has been denied by the.
What is your name?
N. Patil.
Heard Mr. Passes for the petition. Also heard Mr. P. Goswami, the passes for the phone number. The Mr. R. This person. This part. Why? Order this. This is the order. Page
Page 24, page 22. Start from page 20.
for twice order dated
21.
24/7/23 passed in WPC 6490 of 2020. And directed the petitioner, had given liberty to the petitioner to submit his unpaid bill in the proper format. And therefore, the Director Information, Public Relations, Printing and Stationery, SAM, and the Director Food, Civil Supplies and Consumer Affairs, SAM, were to make necessary verification as per the petitioner's entitlement. And upon verification, if it was found that the petitioner was entitled to the amount of money claimed by him, the set amount was to be paid to the petitioner. Mr. B was submit that committee that had been constituted on 30/07/2024 to look into the case of the petitioner and others, and held in its meeting minute dated 24/5/25 that the petitioner was entitled to the payment of rupees 7,46,257.50 in respect of two bill. Yes, it's two bill. Where is the third bill? Where does it say that cannot be done? On out here, where does it say that third bill cannot be considered? Mr. The minute of the meeting minute date is 25/4/2025. Provides that the director printing and stationery will submit necessary proposals to the government with the IPR, PNS department for payment of the aforesaid pending bill under the relevant head of account of the budget of the IPR, PNS department in the current financial year 2025-2026, where sufficient fund is available for payment. Next up. So when will you pay?
Only after we got things on order, like.
Did you give, we'll list it again. List the matter. On. 24 June.
Like,
Okay, you hurry up, you long time pending.
already when your response number one,
You said that there is money out here. When money is there, why not give
I
it?
got I was taking some basically not from the previous one. So.
So you go and apply to the sanction, to the finance department for sanction.
Okay,
Yes, you apply. Wherein the respondent shall show that sanction has been asked for from the finance department. You take that photocopy. You take it. Okay?
Thoughts? Documents. Like copy. Agent of the no document coordination. Practically, the document which.
You see, your writ petition was filed in the year 2018. It was disposed of in 25 April. Now you have produced the document.
That statement something made.
You are playing hide and seek with fact. No, I'm not allowing.
Because of a lapse on the council, because
No lapse on the.
that.
If there's a lapse on the council, please make him a party. Supreme Court order is there that if you're going to lay the blame on the preceding lawyer, you make him a party so that he can defend himself.
Sending themselves one aspect of the matter. Fact of the matter remains that for the future appointment.
I don't accept it.
So the original is also enclosed, but copy of the original is also enclosed that is in garden. That's why you have to say. That is the least possibility. So that the appointment was taken. And what the.
In 1982, to a 12-year-old. Correct. How old was he in 1987, according to you? Huh? No, he was born when? He was born, according to you, in 67. So in 87, he would have been 10 years old.
87 could have been 20 years.
Huh? 87. Okay, that 87. Achha, there, wait.
So you're not started finding that he made that he got 20. He made it taken as 58 minutes. On 1987, he become over.
He was appointed as an office peon on 15/11/1976.
That was a temporary appointment. That was.
When? So when he was 9 years old, he was appointed.
No,
that, to that,
A temporary appointment.
to that extent, my lord, there is an order. The lordship will kindly come for this copy. Was working as an office clerk and in his service record also because it has been indicated that the period prior to 1987, whatever period he has put in, that will be only regarded as a voice service, and from 87 only his service has been recorded. The lordship will kindly come for page 40.
Yes.
That was a letter signed sent by him, where he made it clear. And the lordship kindly see the endorsement on the different side. Has been serving under me as my personal John he appointed. So he has not yet received the formal appointment. Formal appointment came only in the year 1980. And in his service record also, my lord, was indicated that the period prior to this will not be reckoned towards the service. Length of service. The lordship will kindly take paragraph 14 of the
Yes.
page 13. That will very 13 paragraph 14. If it is not saying that service book is 24 that will specifically reflect that there are service book. It is a small service. And that big system in the service book is famous. That the actual date of birth was not counted for the purpose of strategy. Length of service for completing this document. Now, if below the date is taken as 1958, which the respondents have projected, then in the year 1987, he cannot be appointed. That's all. You'd be 29 years old on the date of his appointment. Quite past the operation. These aspects were not born into. Projected there. That is the area without there. The law may get considered. The subsequent order that we on
Yes.
page 43 and 43. As per memo number 12, the end of it. Due to completion of the order for demand service and work in the government that has been permanent from repayment. Here also the vernacular is there, page 43A. That's all. There, and particularly since your lordship has held that he that will depend as of the PA by submission to that there is taken. The year 1987 not have been made permanent appointment. So you become operated by 4 years.
I don't know. Since he could be working for the government on a temporary basis when he was 9 years old, why not?
No, he was not working for the government, but he was working as the personal field. So there is a distinct all respect to the management of working as a personal field, working as a temporary appointment of the government.
The repetition doesn't say so.
So these two documents are defined in this particular. So what we have been paid, however, was not. Our background because
He was engaged by the respondent authority on 15/11/1973 as office PR. That is the risk petition. Anyway, right. Third, Mr. S. Datta, yes, for the review petition assisted by Mr. E. Vishwakarma. K. Vishwakarma. Vishwakarma. To submit that the few order dated 4/4/2025 passed in WPC 5042 of 2008 is be reviewed in as much as the learned, the earlier learned counsel appearing for the review petition had not annexed a copy of the order dated 17/7/1987 issued by the District Elementary Education Officer, Ipsaga, in the writ petition. Only that, what else? And the particular page 40. And order dated 15/10/87 issued by the District Elementary Education Officer, Ipsaga. Next one, the review petition subject. The review petitioner's counsel subject that if the above two orders have been made a part of the writ petition, comma, the same would have shown that the review petitioner had been employed as a wait, in 1976 what? Was employed as a, was appointed as a permanent, was employed as a personal peon in 1976 and was appointed as appointed as permanent lower grade assistant come typist in 1987. So he also submit that the service of the review petitioner as a lower grade assistant was made permanent with effect from 1910/1987 on completion of 3 months service as lower graded. Correct. Then what else?
But here is overrated in the year.
So further, if the petitioner's review petitioner's age was taken as 15/5, no, as 31/7/1958 and not 1/12/1967, comma, the review petitioner's age at the time of his permanent appointment as lower grade assistant come typist on 17/7/1967, comma, he would have been over it. Why? What is the age for appointment? Huh? In as much as the upper age limit for appointment during those times was 25 years. Where is the proof?
But I can still believe it. Not on me today.
Post up next time. Anything else?
Oh, that's good. And his service standard has also had a 14-year lot. His service has been reckoned from it, not from the.
Maybe.
The service book also is.
I will consider auto reserve. No need. No need. No. Need.
But already my love 14 witnesses have been already my love because of 14 completed. Which is 6th of January to come to the regarding. Anyway, my love within 2 weeks we complete the my love hearing and pass out. Considering the
You see, this is already with regard to representation.
representation, my love, to pass the representation, my love, things because it's a complaint, especially from the my love, local resident, reason as well as oral complaint are there. So, my
Okay, let's give that. Well, not for the respondent, granted the further 2 weeks. So, implement of it.
right.
We're supposed to go for what the rate, at least whether otherwise you succeed whether you be L1 or not. So it's that email was huh? Whether it should be otherwise you be L1 or not. Okay. Then the order passed by your lordship on my lord 25 425. Para 425. Yes, para 8.
Have you filed anything like it?
Whatever my lord, making my lord.
You give me the piece of paper there, what is your paper?
We can say whether otherwise I find it the result for you on the last.
Oh, yes, sir, correct.
Yeah.
So what is your, where are you?
L5.
L5, yeah, how does it matter?
No point again opening the financial bit now. So they have only to process.
You have already, his financial bill is L5,
No. He says, madam.
in L5.
But as the financial bit part is concerned, it was open. During before he approached the honorable court. So I find the result. He need not have to declare his account, but let
Nothing is, it's all academic interest. But all academic.
On this ground, again, it is rejected. Even at both are. Directing us to again open the financial.
No need. Financial bit not required, but we can say that the rejection was wrongly done. Yes. Yes. Yes.
The yellow is the other job, but awarded to be on 21 to 2020.
21 to 25.
But
Okay, so this bid was submitted on 10 to 25. So there's no question of putting this. That is different. This case does not cover. This case is different. In this case, if I remember correctly, he was L1, but his justification had not been his called for. Justification had not been decided. So that is why this court said that till his justification is decided, he cannot be declared to be a winner. So that is the difference. Right? But this case is correct. Out here, if your bid was, if his bid was submitted 10-2, and when is the last date of submission of it? The last date. And LOA was issued to you on 21 to 25 in another case. No, no, it is, but then that was after his bid was submitted. Then, but then another thing, were you L1 in the earlier case? Winner? No, no, Mr. Counsel, there's another thing. You see, this then it cannot be so smart. Out here, wait, where is that clause?
Yes, 2.2. Let me find that page number, 57.
No, no, where is that tender clause? Show me here.
Page 57.
Page 57.
Clause 2.2.
Clause 2.2.2.9. Which portion? 2.2.2.1. Huh? See. Ah, you see, this is different. Now, in your case, when was in that other case, your financial bid was opened when? No, 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 in the earlier case, where your LOA was issued. It is not so simple, Mr. Counsel. When was your financial, you see, out here, because the tender clause says that if you are L1, and even if LOA has not been issued, then that has to be mentioned in your bid document. Correct? Now you were LOA. You're given LOA. But prior to that, you were L1. Most probably you were L1. You're being very quiet on that aspect. Correct? When did you know you were L1? Ah, so your repetition might fail. Your repetition might fail. Yeah. You want to take up, we'll take up, but we'll allow the tender process to carry on. No case. For what? Why? 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 You've got your L1, your L5 according to you. Even if you succeed in the repetition, you are not going to get the tender. Yes. What do you think? I've got only your matter to decide on. I've got so many matters to decide. Different, Mr. Counsel, the facts are different. In the case that I had decided earlier, out there, he was L1. But since his rate was so low, or unusually low, justification was called for. So the government held that because he was L1, he should have stated that he was the winner. Maybe, but were you L1 here? Not in this case, in the earlier case. In which job were you L1? LOA was issued in which particular case? Page 121. Huh? Yes? Yes? No, this is LOA, this is LOA. Prior to LOA, when did you know that you were L1? You did not know before, prior to this date. Is it? You see, there are two aspects of the tender condition. One is where you are the, you are the winner, but LOA has not been issued to you. Another is when you are LOA, L1, but LOA has been issued to you. There are two aspects. So when did you know you were L1? Prior to issuance of the LOA, when did you know you were L1? And you don't know yourself. And you want to argue the matter. I think the end of the matter, nothing. You can file another case. You get a picture of you. Right. Heard, mister? Huh? Taking Gupta learns how to for the petition. Also heard Mr. P. Gupta learns how to for the petition. This is order dated page 25 for 25. Huh? Para 2. Then you write, para 3, right? It's the principal learns how to for the petition submit. That the petitioner was given letter of acceptance bracket LOA in respect to the contract work, but Mr. Counsel, though it's very welcome what you are giving. The problem is once we start dictation, our train of thought gets derailed. You better again come back. Please don't disturb anymore. Okay. So what have I said? Then, respect of the contract work at page 121, subsection. On 21 to 2020. However, the petitioners, the petitioner had submitted his bid on 10 to 2025, which was the last date for submission of bid for the present contract work. In terms of the NIT, dated T1 2025. He submits, he further submits them. This court has disposed of a similar case, that is WPC 2068-2025. And accordingly, the present bid petition should also be disposed of in line with the judgment and order dated 16/5/25 passed in WPC 2016 of 2020. Yes, sir. The petitioner counsel has also submitted that as he has been informed of the rates that bid given by the other tenderer, the bid offered by the petitioner is L5. The financial bid offered by the petitioner. Mr. D over, and counsel for the respondent subject then. As the petitioner's bid is L5, there is the entire exercise is only of academic interest, even if the petitioner's bid petition succeeds. He accordingly submits that the petitioner would have, he accordingly submits that the writ petition should be closed, and if the bid is to be given to, if the bid is not going to be given to the to the bidders who are L1 to L4, the case of the petitioner can then be reconsidered after, prior to taking a decision for awarding the contract. A bidder whose rate is higher than the rejected. Then take your, so, next one. The basis for this qualification of the petitioner's technical bid has been laid down in clause 2.2.2.1. Triple two one, huh? Where is that? A page? 2.1. At B. At B, huh? At sub clause B. Sub clause. Page 57. I put it in black. The reading of the above would go to show that the winner of a bid where LOA has not been issued as on the day before opening of the financial bid has to also what happens? They have to do what? These persons, the winners, they've got to give information regarding their winning status. Correct? Yes. Have to give their status of the being a winner in respect of some other contract, some other tender notice in next year? In next year? Huh? The first one, 2.2.1. First one. And next year, Roman 6 of Appendix I capital A. Huh? Not I, it'll be one A. Legal lots will fight with them on the second lot, first line and second lot. No, anyway, next. In the present case, the petitioner has not been able to inform this court as to when he became a winner. Then if you are a winner prior to that, then they have correctly dismissed, rejected. Justification of conflict. Okay, so justification was conflict. Whatever. Became a winner in as much as, in as much as. Though the petitioner was L1, comma, he was asked to submit a justification for his abnormally low rate. That's what it said. So it will be covered then.
So the result of financial sheet was opened on 11/4/2020.
Correct.
So the what says that before opening of the financial sheet, you have to be given. So please,
357.
the explanation given is for the sake of clarification, mention that was for return and reverse and return of the pitch, but LOA was not, has not been issued as on the day before.
Before opening the financial.
So financial sheet was opened on.
Acha, this was
11th
way-
of the- LOA was put on. Yeah, the LOA put on 21.
Okay. And the financial bid was opened on?
On my log 11/4/2020. In the present tense. So there is a difference.
Okay, we won't say anything. Whatever I said. We'll stop. Next. Without going further into the merits of the case from this court is of the view that as the petitioner's financial bid amount is L5, as has been submitted by the petitioner's counsel. comma, The issue is the question of deciding whether the petitioner's technical bid was validly disqualified would only be of academic. As such, our this court is of the view that the risk petition should be closed at this stage. Accordingly, accordingly, this court is of the view that unless the respondents are deciding to award the contract to the tenderer who has submitted financial bids higher than the petitioner. The work contract to be awarded to the bidders whose financial bids are lower than the petition. Should not be discussed unless the same is in violation of the law. Accordingly, this petition is closed due to the following reason. So, however, if the petitioner, if the financial bid whose bids are higher, whose rates are higher than the petition, is to be awarded the contract, the respondent shall not take any action without giving prior personal hearing to the petition. So that it will give you time to come in. The petition accordingly discussed. Okay. Mr. B. Chowdhury, Lieutenant Counsel for the PW, is granted more time to obtain the
Termination letter and the proper.
termination letter and the show cause notice that might have been issued prior to the of issuing the termination order. This is the matter. When? When do you want? At the position. Okay.
What is all the document? Thank you.
Huh? It's a settlement order, not issue.
Planet has not made corporate society as a partner. This is a necessary part. Yeah, they have allegations that against cooperative society. This is a cooperative society. And these are 100% fishermen. I am here to fix my keep going. Not excited.
He's cutting short your argument so that we don't waste time.
I'm not wasting time. I don't have.
No, that is his thing. That's what I'm saying.
Now, what are 500? Application by the and my case is that my house,
They are not 100% fishermen.
they're not 100%. And we have filed an application of the other mother to get so mother to become that mother there are 9 members who cannot who cannot be member of the system. And we have given all the protocol. And mother then have not been considered to customer order into the school. And mother people also thank mother define they take your hospital to the competitive statement. Really, mother, previously, here my lord actually is 40. That particular column, my lord, because it's the 100% that is not there, mother, is mother, the competitive start. And my lord, in the application that we have submitted, that you are also find that is 30. We have kind of already informed the initial Treasury Department, saying that kind of this is the person, and we have given the list, kind of this is also here. These are the persons which are not one of the members of the society, the kind of county or kind of the one of the members of the kind of the 40. I'm just kind of pointing out to you about it.
No, who are the persons who cannot be members? Page 40.
My lord, this 40 about it. Because that we have to represent.
Who, all of them?
All
of them cannot be members. Huh?
9 of them. 9 out of there are 80 members. And there are decisions by the promotion in this dictating this society by the reason they have some of these members are not available and therefore by the not I'll take the question also by the. So Russia can be comes to this 40. Pillar number 1. He is a mother broker economy.
Serial number?
1.
Page 40.
This 40.
Yes.
He is a mother, we have become a different picture. But before they might have also settlement of picture. He is a mother broker store owner. Then my lord, pillar number 9. Only from Bida is a government oldest pensioner.
Is that?
Government my lord pensioner. Then serial number 24, my lord, he has long expired. Then serial number 26, sorry, my lord, 38. He is a my lord serving life sentence. It is jail. Monia Hira. Serial number 49. Tompo Hira, he has a my lord grocery store. Then my lord, serial number 52, Gurun Hira, he is an employee of the State Bank of India. Then serial number 53, my lord, he is a student of the college or law.
And all these are some kind of property multiple evidence. So that my lord, your confidence, we can endeavor making actually better you are. And as I have told my lord, the competitive chart, it's not keep that problem, but the problem is what. But therefore, my case, you know, let them make an excuse. And but all the big settlement also be there, but the possibility of the because the amount of responsibility. And the decision, earlier decision of this honorable court, my lord, concerning the same person, same kind of of course, long time ago, they had part of citizen also some other question. And the honorable court said that 2% some kind of local percent of their kind of that you want to be fine. What is saying a lot of the presently honorable court. And the honorable court.
So you have got a long history.
Well, they have got a wrong history of taking part of effort for another. December 30th.
Just for me. Which page in this order?
In this
Para-
order, my lord, paragraph 19. This now refers to the,
Yes.
this now refers to the second of the two of the members of the. Even advocate for the two people, above are owners of property of the fact because corroborated the activity by the however, the only thing we can was that the after the committee member and the member themselves are not the fact is that two of the members of the society are owners of the and thus do not have to become members of the society to identify as public protected. And finally, the government, otherwise, the executive, they are being now by the protected.
Okay, well, people is like, these not 30. I one day before the issuance of a reasonable
Yes, yes.
2 days, but
only one day before issuance of settlement order.
what day is doing for different.
27 5 there is no stamp order, page note 30 order.
Yes.
Page number
27,
27. We have issued on,
page 34.
we have issued on 28 order. And again,
Settlement order issued on
28. Well, lots of maybe already it was been approved on 26, maybe not the 5. So only the issuance.
this, so we'll let them be appear in practice.
It can turn out to make just not making the position. Well, then the position is given by the there is there not making this. If they are right, you get those.
So why don't we dispose of the entire thing? No, no. The thing is that we will direct the authority to look into their representation. Let them take a decision.
Yes.
Okay. Page number 50.
Document submitted as to along with the later document, the debtor,
Page 50, where? 50.
50, number 1.
Number 100%.
Retirement certificate, completion of 100% retirement certificate of retirement cooperative society as a case and so by the AR has indicating that all the members of the retirement cooperative society, with the community or minor community of first point, Contractor, district of Contractor, I have this document. For that is concept of 100% excess retirement after inquiry loss repair with an and the allegation that was against the loss, they have no documentary evidence. They got the document loss with ISR and so of pension of the section. Because not the earlier district has surrendered this in the month of the month 5.
Who is running the fishery right now?
Forwarding guarantee is not good for 1 year.
And
We have to go to the- No, what we'll do is, we'll ask the,
and take up tomorrow, I.
madam, can you listen? Let the authority take a decision on the petitioner's representation. And if the authority wants, he can hear both sides or not hear either of them. Yes, otherwise, giving a personal hearing will take too much time. Okay. Ah,
Have to go as per the society.
ah,
So what the society has given us a certificate. So inquiry has to be done by the property. So by the society is the domain, they are the competent authority. They have to say that yes, they are not 100%, they are that. It's an issue we have to. It cannot say inquiry can inquiry to the. So if the board of members say that yes, they have, we have not asked them to particularly in the fee, then I can, you can take it, but not require them. So, yes, I think before you require the deputy commissioner to contact the inquiry.
so you see, according to your allegation, you have to prove it. Right now, it's only your allegation. You do not know.
I want him to find out the
There will be certain, but then we cannot solve everything. I was just thinking that it could be solved this way. But if it's going to take ages,
the rules for the deputy commissioner or contact the inquiry.
let it be done, but in the meantime, let it be, we won't disturb the process. But let the authority decide the matter within a specified time. Ah.
Right to the property protection.
In the meantime, that can be given to them for the.
I understand it also. With all activities.
You have to do it. Who will do the exercise? Ah, corporate society. Who issues the certificate? That is the corporate society. Then the external staff will have to do it.
Issued by the.
They have not even made him a party.
One of the. Obviously, you. And we can.
You see, actually, our trying to do things with us. The thing we have to issue notice, let it go.
Why did the deputy
Commissioner do it? He's not the authority. Was he the one who issued the tender?
Yes,
He issued the tender. He's the one who settled the tender.
no, I've issued the settlement order.
Ah.
Like just forwarding it. We have authorized it only to the person and I need to keep it, nothing else.
Who does the scrutiny of the, you do?
We do the scrutiny, but we are dependent on the certificate issued by the control department. Not by the entity. We have no right to go into the domain of the property. I know the completely.
So, why don't you go to why don't you,
We can ask what's it, the property to take to, as because they have given an extent. The investigation. After property to take to make an inquiry and give us.
Ah.
But it will take months, several months. Yes.
you have not made the cooperative society a party? No, I'm not like that. If you want, if you like, you see, the thing is that if we ask him to verify, I can do it. He's going to bring out the certificate. Now, whether it's genuine or not, that would have to be again verified by the authority concerned who issued the thing. no,
Deputy commissioner is there, so the company person never, do the deputy commissioner never to think forward, they have to forward everything to. Which producer, what method, the problem of the person, but they have given. Who have signed the additional district commissioner, but they have to, they have to register the development officer. And the fishery department is a part of the, we can afford it, but they have to, we cannot know.
okay, we'll take it up tomorrow. With you, because, no, I have to give them, some chance also. Their right is also being going to be taken.
For the 46.
Page 46, yes.
46. What can I do, Lord? If you did it, column number 1, 2, 4, 5, 6 number column plus certificate of teaching.
Yeah,
Column number 1, 2, 4, 5.
the certificate of fitting.
It is submitted to us, Lord. What certificate? What certificate of teaching? No, this is certificate of teaching expertise. Expertise. Cooperative society certificate. Then again, cooperative society certificate is also submitted. So everything is fine. My, so cooperative society have been a part of it.
Should have been a plan. So that we could have directed them also to complete within a time bound manner.
Not the political, cannot be.
Otherwise, if you make them a party, then we can ask them to, we can ask these guys and the AFDC and the fishery department and that, thing to decide the issue within a span.
Yes. Cooperative society is also the political. Working. They are not our members.
Yes. The person who issues the certificate.
Yes.
They will have to. Otherwise, it's difficult for this person. Because even the DC, how is he going to decide the authenticity of a certificate?
Already, I think already.
But you see, it was given on 27 of, 27th of May.
We have already approved lot, I think.
Huh?
In the fight with the department of.
Anyway, right. If the case authority doesn't see the cause for the particular, says that he will be allowed to withdraw the writ petition, with liberty has been, this is the matter. The writ petition, the pair of the petitions counsel is allowed, the writ petition dismissed as withdrawn, with liberty has been.
I know.
So you have to be ready, he is filing tomorrow. You give a copy to the madam also. So you get ready with your senior counsel.
No, not excited. We are waiting. You know, since 1 year, since 1 year, my daughter friend has got that is even went also to get the NIT. Now they are.
I think it's very lucrative.
Yes, it's a look, right? I know the official value is 2.5 there, and one of their actually.
Okay, then what is this? This is that other banner.